Oh, right. Right. Good morning, ladies and gentlemen. My name is Judge Law, and we're going to begin with our misdemeanor all-purpose calendar with the State Court of Fulton County. These are cases in which individuals, have been recently arrested, not recently arrested, but have been arrested, and their cases have been formally accused. So we are going to get the status of the cases. This is technically a plea and arraignment calendar, and in which cases we'll also be addressing bond modifications as well as setting aside bench warrants and so forth. Good morning, courtroom two. I don't know who's counsel in there.
Good morning, Judge Law. This is Attorney Mirsajidin from the Public Defender's Office. Here in person in courtroom two. We do not have most of the defendants for today's calendar in the room yet. I know that the jail staff is working on getting them down here.
No problem. Thank you, Mr. Mirsajidin. Let me see now. So I'm not going to complete my announcement at the present time. So let me get through some housekeeping matters. Ms. Yingli, good morning. And which case will we be addressing for a Mandarin interpreter?
Position 38.
38,
Your Honor.
thank you, Mr. White.
And we'll need a breakout room when he's in.
Okay. And anything to announce before the folks come into the courtroom? Mr. White,
Nothing beyond what we've submitted at this point for me.
Okay, sir.
Judge.
Got it? Okay. And who's our other PD counsel this morning? Besides you, Mr. White and Mr. Mirsajidin, just the two of you?
I believe Mr. Bartels may be coming to help with just a couple of the cases. He should be here shortly.
All right, and I have Attorney Michael Lascala. Mr. Lascala, are you there at your desk or just
Good morning, Judge.
morning, sir?
I have my client here with me too.
And what is this case for?
This is Devin Kasmar. It is 2 cases on the calendar, and it's 2 very old DUI cases.
Kasmar.
Kasmar. I've got the position number here.
Okay. And give me the position numbers.
It's 24, 25. It should be 26. I'm sorry, 23, 24, 25. And that is on the state all-purpose.
23.
Right. 23 is the
What's the name again?
Kasmar. Kasmar.
So he's right now in the office with you?
Yes.
Okay, so typically when they've been released, they don't go on the SAP calendar?
I had this conversation with my client this morning.
Okay, and the cases are further notice for trial?
Yep.
And he's been released on bond. Is there the only thing he's
You're up.
required to do from this point onwards is to make sure that his address is current with the courts at all times, that he complies with the conditions of his bond, and that he shows up to court when summoned.
Your Honor,
Yes,
I'm
Mr. Wall?
I'm not sure. This is probably Ms. Falk's case, but our calendar shows null pros. I'm not
It's not, but the calendar does show no prost. We should either have no prost that case or should be no prosing that case today.
Yeah.
That's Mr. Kasmar?
Yes, it was on the previous calendar before the updated calendar was sent out, Your Honor.
No
Okay,
problem.
it's a good
All
thing I
right.
printed the updated calendar. So Ms. Falk, go ahead, and what are the case numbers and which cases are null pros for Mr. Kasmar?
Let me pull those up. And I don't know if they have been null prost yet. ASG Nixon can advise you of that. Let's see.
Good morning, Your Honor. Yes,
Morning.
I'm working on all those no pros orders now.
Okay, so after the null pros orders are signed and filed, are there any pending misdemeanor cases against Mr. Kasmar from that point onwards?
Not that I know of, Your Honor. The two case numbers are 10 CR 359209 and 10 CR 363436.
And Mr. Nixon, you'll be submitting the null pros orders for both cases?
Yes, Your Honor.
All right. Mr. LaScala, were there any other cases beyond the two identified by Ms. Falk?
No, thank you so much.
All right. So in that case, as soon as the null pros orders are signed and filed, the cases are dismissed against your client.
Thank you so much.
All right. Thank you, Ms. LaScala. You're free to go.
Bye-bye.
Bye-bye. Okay. Let me see. All right, I got four individuals here, so maybe you can tell me if you're an attorney or a friend or a victim or a friend in support. Mr. William Davis, Tabitha Stewart, Latoya, and Rashadra Hicks. Are y'all attorneys representing an individual who's going to be addressed today?
Victim.
Victim, okay. So if you're an alleged victim or a friend or family member addressing a particular case, please mute your screen and switch your video off. When that particular defendant is being addressed, then you may start your video and unmute if you want to address the court. Okay, thank you. All right, Mr. Davis, go ahead and switch your video off too. Okay, now Mr. Mesarjadin is still there by his lonely self, so we can do a couple of go down the calendar a little bit. Position number 4, 5, and 6. Bacchus, Tamonte Bacchus. They are going to be reset to, is it July 8th, Ms. Champion?
That's correct, Judge.
Okay, I just want to be sure we have spaces on July 8th. Is Ms. Champion my LM today?
Yes, ma'am. We do have spaces on July 8th.
Okay, so 4, 5, and 6 are reset to July 8th. Position number 14, Christopher Collins. It's also going to be reset to July 8th.
I think that's going to be July 3rd, Donna.
Or July 3rd, excuse me. Okay. Same announcement for position 21. Stanley Farley is going to be reset to July 3rd. '26, 27, and 28. Robert Ingram is going to be reset to July 8th. That was 26, 27, 28. I've got a lot of need to see, so I'm hoping.
Some issues with
Yeah.
the calendar yesterday, plus couple floors were on lockdown at the jail, and of course the interpreter.
Okay, no problem. All right, I don't have any other, and I have an add-on for Edward Charles. Is that correct? 4 positions for Mr. Charles or Mr. Edward? Okay. Were there any other resets from this calendar other than those I've identified? No? Okay. All right. Mr. Mesarjadin, based on the 57 or odd cases we have on the calendar this morning, are any of them going to be announcing a waiver of arraignment and further notice for trial? Good
Um,
points. And slowly, please, as we go through the calendar.
Yes, Judge, I'll make announcements here for all of the public defender clients that are waiver of arraignment and not guilty. That is going to begin with position 31, Cornelius Martin.
All right. This is are you filing a waiver of arraignment?
This is Mr. White's client.
Yes, Your Honor.
All right. No problem. So when we all announce waiver of arraignment, I'm assuming you'll be filing that and your client won't have to be seen at this calendar today. Okay.
Yeah,
Correct.
Okay, so we're going to begin with Cornelius Martin. Anyone else?
Position 34, Jalen Owens.
Okay. Next one.
Position 36, David Pitts.
Yes.
Position 41, Michael Smith.
Yes.
Positions 42, 43, 44, 45, and 46 are all the same individual, Zektar Stiggers. Those are also waiver of arraignment, not guilty.
Yes, sir.
I'll talk with you next.
Anyone else?
Position 49, YA White.
So waiver arraignment and further notice for trial. Okay.
And finally, position 57, John Youngblood.
Okay. All right. And this would include the announcements for both yourself and Mr. White.
Yes.
All right. Good morning, Mr. Bartel. How are you, sir?
Morning, good. How are you doing, Ron?
Doing well, thank you.
Good. Yeah, I just wanted to let the court know, I have two clients on this calendar that I will need to talk to. They weren't available when I tried earlier. But I'll talk to Mr. Ellison, number 20 is already here. I'll talk with him, and I also need to talk to Ms. Carter, number 12 at ACDC.
Okay. As these folks show up or the cases are called, or if you see them on the screen, ACDC hasn't appeared yet. Just let us know. I think you may have to call ACDC to do
I think so.
your confer. Okay. All right. And Deputy in Courtroom 2, we have a Mandarin interpreter for 38. Is the defendant male or female? That's a female. So most likely at ACDC, Mr. Masajidin?
No, I think she's in medical, but we haven't pulled her yet. Because I
Okay.
know the Mandarin interpreter was gonna show up, so I only pulled the male.
Okay, thank you. Are you bringing in anyone else at the present time?
Or we're good to go with that.
We're good to go right now.
Your Honor, we can proceed with the individuals that we have present in courtroom 2 now.
Thank you. All right. Good morning, folks. My name is Judge Lal, and we are going to begin with the state all-purpose misdemeanor calendar. Today, we are going to address each of your cases on a one-on-one basis to determine the status as to whether you want to enter a plea and accept a recommended sentence, or whether you would like to enter a not guilty plea and have your case reset for trial. Other matters we may be addressing are issues like bond modifications, bench warrants, and so forth. If you are a defendant charged with one or more misdemeanor cases, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. As I've previously announced, if you are a victim or a alleged victim or a friend or family member, please make sure that your video is off and your audio is on mute. You may come back on the Zoom when we are addressing the particular defendant that you want to be involved in. Okay, courtroom 2, who do we have first?
We can do position add-on 1 through 4, Mr. Charles.
Yes, Edward.
Okay. All right, this is Edward Charles or Charles Edward, do I address him as Mr. Charles or Mr. Edward, Mr. Masarjuddin?
Mr. Charles.
Okay. Mr. Charles has got 4 matters on our add-on SAP calendar. 22 CR 004-283A, 22 CR 008-497A, 2 bench warrants, 25 FTA 1183 and 1184. Mr. Edwards, you've been advised of your right to remain silent. Your attorney is Mr. Masarjuddin. And with respect to, I'm sorry, I printed like maybe 100 pages and I can't find the add-on. So give me a moment. I'm just pulling it up on the Odyssey. And with regards to the case ending in 283A, these are a charge of driving without a valid license from April 27th, 2021. And with regards to 22 CR 8497A, Mr. Charles is accused of theft by shoplifting from January 30th, 2022. Both matters are in bond forfeiture. Looks like he's got a bond forfeiture calendar before Judge Roth tomorrow. So in the meantime, Ms. Falk, how are we proceeding with this case?
Your Honor, I think this was an announcement as a non-negotiated plea.
Okay. Right. So Mr. Charles, if you raise your right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Sorry?
Yes, ma'am.
Thank you. All right, Ms. Falk, what's the recommendation for driving without a valid license and then for the shoplifting charge?
Well, if I could inquire with PD Masajidin, what exactly is the non-negotiated part of this?
We would just be asking that the fines be converted to community service for Mr. Charles, and if possible, to have the probation become non-reporting upon completion of the requirements, and as well to have the fees and such associated with probation to be waived at least for the first 3 months for Mr. Charles.
Well, for the first and second, state has no objection. The third would be up to the court. So I don't think this is a non-negotiated plea, Your Honor.
All right, I don't have a problem converting it to community service. I'll waive his probation fees for the first 60 days upon his release. And then after that, he will need to start paying probation fees from month 3 onwards. If he has completed all his conditions, his probation will be non-reporting.
Mr. Charles is going to accept those terms and plead guilty.
All right. Ms. Falk, what's the recommendation, please?
Yes, Your Honor. The state's recommendation as to driving without a valid license is 12 months served 20 days, credit for time served 10 days, which is from June 17th, 2025 until today. Balance probated, and instead of a $265 fine, that would be 25 hours of community service. On position number 2, the theft by shoplifting, state's recommendation is 12 months served 26 days, credit for time served 13 days, balance probated. Instead of $500 fine, it will be 50 hours community service plus another 40 hours of community service for a total of 90 hours community service. Anti-theft course, stay away from the Walmart located at 6149 Old National Highway. This is to run concurrent with the previous case. Positions 3 and 4 will be a null pros upon the taking of this plea. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Defense so stipulates.
Okay. Mr. Charles, have you consumed any medicine or alcohol?
No, ma'am. No, ma'am.
Have you understood what's going on in your cases?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
Has anyone forced you or induced you to take this plea under pressure?
No, ma'am.
So you understand that if you enter a guilty plea, you would have to give up your right to a trial before a judge or a jury. You won't have the opportunity to go back to court to confront your accuser, challenge the evidence brought against you, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up your rights?
Yes, ma'am.
How do you plead to one count of driving without a valid license and one count of theft by shoplifting?
Guilty, ma'am.
On the license matter, your sentence is going to be 12 months to serve 20 days, credit for time served 10 days. You will report to probation on Monday, June 30th? Yeah, last day of June. If you can't remember the date, at least it'll be the last day of June, and you report before 3 p.m. I will waive your probation fees for the first 60 days upon your release, and you will have to start paying probation fees from month 3 onwards unless you have satisfied all your conditions. For the driving without a valid license is going to be 25 hours of community service at any nonprofit agency that's not a church and not a school. And once completed, the agency supervisor must give you a letter with the company's letterhead signed by the supervisor indicating how many hours you have satisfied. For the shoplifting, it's going to be 12 months to serve 26 days, credit for time served 13 days, balance probated, same conditions. In this particular case, you will do a total of 90 hours, 90 hours of community service. And within 60 days of being released, you will enroll in an anti-theft class and make sure you complete the class. At all times, when you are on active or non-reporting probation, you are to stay away from the Walmart store at 6149 Old National Highway. Just FYI, you most likely want to stay away from all Walmarts because they'll have your picture with loss prevention at all of them. No illegal drugs, and no driving. Absolutely no driving unless you check and see that your license is valid and current. So while you're on probation, before you start a vehicle, check with the Department of Driver Services website that your license is valid. As you know, Mr. Masarjuddin, pleading guilty to driving without a valid license will trigger a license suspension. All right, thank you. Oh, and his probation will be non-reporting once he's completed all the conditions and he's up to date with any and all probation fees and costs. Thank you. The 2 bench warrants, positions 3 and 4 are null prost.
We got
Next,
a
please.
position number 9, Mr. Barksdale.
Is that on the add-on or
No, just a regular number 9 again.
regular count? Okay. Robert Barksdale is accused of theft by shoplifting from June 12th of this year, case 25 CR 3312B. Mr. Barksdale, you've been advised of your rights, and with regards to Mr. Barksdale, this is going to be a plea. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth?
Yes, ma'am.
Thank you. Ms. Falk, what's the recommendation?
Yes, Your Honor. The state's recommendation on the theft by shoplifting is 12 months served 30 days. Credit for time served for 15 days from June 12th, 2025 till today. Balance probated, a $500 fine, 40 hours of community service. Stay away from the Publix at 595 Piedmont Avenue in Atlanta. State has no objection to non-reporting after the fines, fees, and community service are completed.
Mr. White, do you so stipulate?
We do stipulate, Your Honor, we just ask that the $500 fine be converted to 50 hours of community service.
State has no objection.
All right, this will be then a total of 90 hours of community service. Thank you. Mr. Barksdale, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your right to a trial before a judge or a jury. You will not get the opportunity to confront your accuser, challenge evidence that will be presented to you in court, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up your rights?
Yes, ma'am.
How do you plead to one count of theft by shoplifting?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. You'll report to probation on Monday, June 30th before 3 p.m. While on probation, you will complete 90, that's 90 hours of voluntary community service at any nonprofit agency that's not a church and not a school. And you are to stay away from the Publix grocery store at 595 Piedmont Road in Northeast Atlanta. This will include the parking lot, the sidewalks, and the back storage areas as well. You have to stay 200 yards away from that entire location. And anything else, Mr. White?
No, Your Honor.
Okay, thank you.
Thank you.
Position number 55, Mr. Anthony Wilson.
You want to have community service instead of fines?
Mr. Anthony Wilson is accused of driving while license suspended or revoked and failure to maintain lane or improper lane change from March 2nd, 2024. Case number 25CR2215C. Mr. Wilson, you've been advised of your rights. Your attorney is Mr. Masar-Jadin, and this is going to be a plea. Mr. Wilson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth?
Yes. Yes.
Thank you. Thank you. Thank you. Mr. Nixon, what's the recommendation?
Yes, Your Honor. As for count 1, 12 months to serve 12 days, credit for time served 6 days. That's from April 26, 2025 until April 29th, 2025. Balance probated and $1,000 fine. As for count 2, this will be 12 months to run concurrent with count 1 and a $265 fine. The state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
And defense so stipulates, Your Honor, we would just ask that the fines be converted to community service for Mr. Wilson. And again, that he be allowed to have 60 days before the the fees and charges associated with probation kick into effect.
Where is he going to do the 100 hours of community service?
Mr. Wilson doesn't have a specific place in mind, but he is committed to doing the community service. We don't believe that the $1,000 fine is something he's going to be financially able to complete.
Pretrial, do you have this history, please?
Yes, Your Honor, I'm generating it right now. One moment. There's 57 total arrest cycles. Let's see. There's a 2011 theft by shoplifting.
What's the history of probation violations, if any?
Let's see, there's one in 2017. 2018. Another one in 2018, one in 2024. And those are all the ones I'm showing in the last 10 years.
Okay, thank you. Mr. Masar-Jadin, I normally don't inquire about that, but this flags me because nature of the charges and why he's in jail. This gentleman received a signature bond through the jail, and then he forfeited on his bond for failure to appear, and he's back in jail on these 2 traffic-related offenses. Furthermore, given his history of probation violations, I am not comfortable with him ever being on non-reporting probation. I will agree to reduce it to a not reduce it, but amend the $500 to 50 hours of community service. So this will be a $500 fine plus a 50 hours of community service. He'll be required to report to probation every month and be up to date with his probation fees and costs. He is not allowed to drive. This will be a license suspension, mandatory license suspension for 12 months. In the alternative, he's been in jail now for 6 days. In the alternative, the court will consider 2 months incarceration, credit for time served, and the case is closed. He doesn't have to accept the plea. He has a right to a trial.
Your Honor, I just want to be clear on the initial sentence that Your Honor.
I will amend it to 12 days, credit for time served 6 days, balance probated, a $500 fine, and 50 hours of community service, no driving for 12 months. And he is on active probation for the 12-month period. And for count 2 will be 12 months concurrent with count 1. It's a $265 fine. I'll amend that to a 25-hour community service. If y'all need to talk about it, I can take the next case.
We appreciate that, Your Honor, but I believe Mr. Wilson is prepared to plead guilty to the first offer of community service, the fine, 12 months active probation, and no driving.
All right. And so do you stipulate to the factual basis, venue, and ID?
Yes, defensive stipulates.
All right. Mr. Wilson, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case? I'm sorry?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to accept this plea, you would have to give up your right to challenge these charges in a court of law before a judge or a jury. You would have to also give up your right to have the prosecutor, to be in a courtroom to confront your accuser, challenge the evidence presented by the prosecutor, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of driving while license suspended or revoked,
Yes.
and failure to maintain lane or improper lane change?
Yes.
Sorry?
Yes, ma'am.
On the license matter, it's going to be 12 months to serve 12 days, credit for time served 6 days, balance probated. Upon your release, you will report to probation on Monday, June 30th, before 3 p.m. While on probation, you will pay a $500 fine and do 50 hours of community service, absolutely no driving for 12 months, beginning from the first day of your probation. For count 2, it will be 12 months concurrent with count 1, with an additional 25 hours of community service. So your total obligation would be 75 hours of community service and a $500 fine. While on probation, you will do a minimum of 10 hours of community service per month, and you will pay a $50 fine per month, beginning with month 2. Anything else, Mr. Sajidin?
Nothing further, Your Honor.
All right, thank you.
There you go.
Ms. Champion, please make a note for probation that his minimum payment obligations and minimum community service obligations begin on month 2. So the first 30 days he has just to report,
Yes, ma'am.
not drive.
Position number 15, Brenton Coward.
1-5? Okay.
I'm going to need to speak with him, Your Honor.
All right, and jail, Deputy Courtroom 2, how can we arrange for Mr. White to speak with his client?
Call 404-612-2060.
2060. All right. Could the next case be Mr. Mirsajidin's, please, or Mr. Bartels, if whoever's available?
We can do,
We could do, this is Mr. Ellison, Your Honor, number 20. It's just an argument for a bond reduction.
All right, sir. And did you say position 20?
Yes, ma'am.
Thank
We're
you.
gonna waiver and enter a not guilty plea, but we would ask the court to consider a bond reduction if we could be heard.
Yes, sir.
Yes, Your Honor, he's got
Oh,
10,000.
I'm so sorry. If I just need to state for the record, we are addressing Anthony Ellison, 25 CR 3315B. Mr. Ellison's accused of simple assault, family violence from April 15th, and representing him is Mr. Bartel. Sorry, Mr. Bartel, that's just for the record, but now you have the floor.
No problem, Your Honor, understood. His current bond is $10,000. There's one charge in this case. He has been in for 14 days so far. We would ask the court to consider reducing that to a $5,000 good bond with the same conditions. Mr. Ellison advises me he's from Atlanta, has lived here all of his life. He's got family, including his parents and siblings and nieces and nephews in the metro Atlanta area. He advises me that he works in the city of Atlanta doing landscaping, and that were he to be released from jail, he would still be able to go back to that. So given all that, we would just ask for a reduction to a $5,000 bond.
All right. Tabitha Stewart, please unmute. Will the host please switch off the video for William Davis? He apparently has trouble doing that. Thank you. Ms. Stewart, can you hear me?
Yes, ma'am.
All right. Would you like to address this case? Do you have anything
I'm not a
to
victim.
comment?
I'm not a victim. I keep telling everybody I'm not a victim.
All right,
It was a
raise your right hand.
misunderstanding.
Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Okay, I simply asked you whether you want to say something. I'm not calling you a victim, so go ahead. What would you like to tell us?
It was simply a misunderstanding, and everybody pressed some charges, and I asked them not to. They asked me, did I want to press charges? I told them no.
Okay. And so you don't want the prosecution to pursue this matter. Is that what you're saying?
Correct.
Okay, thank you very much. Please mute your screen. Ms. Falk.
Yes, Your Honor. So just to go briefly over the facts of this case, this was a bond issued by Judge Mincy on June 13th of 2025 in the amount of $10,000. This incident happened on April 15th of 2025. There was a domestic disturbance over at 644 Joseph E. Lowry Boulevard Northwest. Officers went to the location. They could see the defendant throwing a rock toward Miss Ellison's vicinity on a video, which was
I'm sorry, Miss Ellison? I'm sorry, I didn't mean to interrupt.
Sorry.
Miss Ellison?
At Miss Stewart.
Oh.
They mixed up the names in the warrant. My apologies, Your Honor. They showed the video from the package store, showed the defendant throwing a rock at Miss Stewart as she was walking away at around 12 a.m. They were able to pull the video footage to confirm what Miss Stewart had told the police, which is she told the police that her boyfriend, the defendant, threw a big rock at her and she wanted to press charges. So that was her initial statement. The reason I believe for the amount of the bond is there was a previous case on October 8th of 2023 where Ms. Stewart had reported that the defendant and she were at a gas station on the machines, that they got into a verbal argument, and that the defendant pulled a gun out, cocked the gun, and threatened to shoot her. So I believe that that was in large part the basis for Judge Mincy's bond of $10,000. I will say the defendant has a total of 32 cycles. I can just go briefly through the most recent ones. The most recent is use of a firearm by a convicted felon. I will say that there was also an aggravated assault charge. I believe that is the charge that stems from their last contact together, Your Honor. There is a possession of a Schedule II controlled substance from 2018. There is also a failure to appear from 2014, a simple battery physical harm from 2012 that I believe he was convicted on. I just need to take a look really quickly, scrolling up, that I believe he was convicted on, and then a willful obstruction and a receipt of firearm by a convicted felon where he got 5 years with 12 months confinement back in 2010. So I believe it was based on his history, his extensive history that does include violence, that does include previous violence to Miss Stewart, which is the reason the judge gave the bond she gave in this particular case. I do understand that Miss Stewart is now saying that she is not afraid of him. She didn't ask to press charges, but that is not the case at the time of the incident. She did call for police assistance. She did want to press charges at that time. And as Your Honor knows, the cycles of domestic violence work this way, where the victim initially, or Miss Stewart, would initially wish to prosecute and then change her mind about prosecution once the defendant is incarcerated.
All right, Mr. Bartel?
Yes, Your Honor. I would just say that I think a $5,000 bond in this case would be sufficient to secure his appearance at his next court date. I don't believe that any of the recent charges have resulted in conviction. In regards to what Ms. Fox said about the cycle of domestic violence, every relationship is different. And there are other situations where people make allegations that aren't true. So again, he hasn't been convicted of that, and we would just ask for the bond conviction.
Okay.
And Your Honor,
sorry. Yes, go ahead.
just to give Your Honor, I do have the SC number on the aggravated assault, which was against Ms. Stewart as well. That is 24 SC 005094. The defendant did receive a $20,000 straight bond on that, with no cohabitation with Ms. Stewart, not to possess any drugs without a prescription, no alcohol, drugs, or weapons, and no violent contact with Tabitha Stewart. I also want to note that on that bond sheet back in October of 2023, Ms. Stewart came to Zoom and asked to have those charges dismissed, which, according to the indictment that later was taken out by the TA's office, included the defendant pointing a gun at Ms. Stewart and having a handgun as a convicted felon.
Ms. Falk, can you tell me, for this April 15th, 2025 incident,
Yes, Your Honor.
what was the location?
The location of the incident, Your Honor, appears to have been, I know they pulled the video from 918 Donald Lee Hollowell Parkway, which is the package store at that location.
Mhm.
She had walked away from that location, headed toward Lowry Food Mart. And that's when the officers were able to see from the video footage, he threw the rock toward her and hit the store's door. So I believe it's the package store where the incident actually occurred.
Okay, thank you. All right, Mr. Bartel. So I understand from Ms. Stewart's position, but this is not an isolated incident. Mr. Ellison clearly has a couple of, one felony case and now one misdemeanor case involving the same victim, seems to arise from the same similar set of facts. So the bond at the present time on the simple assault family violence is going to be amended to $2,500. It's going to be a surety bond. He's going to be equipped with an ankle monitor, and this will be for a minimum period of 12 months. And the monitoring expense is going to be paid by him per month. He's to have no contact and stay away. Maybe he didn't understand it the first time around, but I hope he understands it now. He needs to stay 200 yards away from Tabitha Stewart. That is the length of 2 football fields. He's not to communicate with her in person, through mail, email, phone, third party, computer device, and even on social media. He is to stay 200 yards away from 918 Donald Lee Hollowell Parkway, the package store, and stay away from 507 Joseph E. Lowry Boulevard. If that's a gas station or a convenience store, I don't know, but he needs to stay away from both of them. No illegal drugs, no alcohol, and no firearms. Absolutely no firearms. He's not allowed to have them on his person, in his home, in his vehicle, or anywhere near him. And this is going to be a waiver of arraignment, so this will be further notice for trial.
Thank you, Your Honor. I will prepare the order and the waiver and get those over.
All right, thank you. And please make a note that he also needs to comply with the bond conditions in 24 SC 005094. Any violations of the conditions in that bond will result in a revocation of this bond.
Okay,
Because they involve the same victim,
thank you, Your Honor.
alleged victim, excuse me.
Thank you, Judge.
Thank you.
Position 24, the roll. You gotta have a seat.
Leroy Frost is accused of criminal trespass from June 10th, case number 25 CR 3289Y. Mr. Frost, you've been advised of your rights. Your attorney is Mr. White, and this is going to be a plea. Please raise your right hand. You solemnly swear and affirm the testimony you provide will be the truth? Yes or no?
I'll let him talk.
I can't hear you, sir.
Oh, I'll let him speak for me.
Okay, that's fine. Then we will just further notice this case for trial, because if you don't want to testify to the truth, then I can't proceed. All I'm asking you is whatever you say, will it be the truth to the best of your knowledge?
All right. Yes.
Thank you. Mr. Nixon, what's the recommendation, please?
Yes, Your Honor. The recommendation is 12 months to serve 30 days, credit for time served 15. That's from June 12, 2025 until today. Balance suspended. Stay away from 3110 Godby Road in College Park. The state will ask that the defense stipulate the venue, factual basis, and identification for the purpose of this plea.
So stipulated, Your Honor.
Thank you. Mr. Frost, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
If you decide to enter this plea of guilty, you would have to give up your right to a trial. You will not be able to go back to court, confront your accuser, challenge evidence brought against you, be able to present your defenses and arguments, and have the prosecutor prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Wait, say that again?
Are you prepared to give up the rights I just listed?
Can you list them all? Can you list them?
You have a right to a trial before a judge or a jury. You have a right to go back to a court of law, confront your accuser, challenge the evidence brought against you, present your defenses and arguments, and have the state prove the charge against you beyond a reasonable doubt. If you plead guilty, you would have to give up all these rights.
For this case,
I still don't understand.
All right. Our case is reset to next week.
Your
for
Honor,
help
if I could
confirm.
have a moment with my client to help him
Sure.
understand.
You can call the courtroom too. Next case, Deputy.
Excuse me, move. Come on, Williams. Position number 52 and 53, Williams.
Thank you. Mr. Mirsarjuddin, this is your client, Teartry Jamil Williams.
Yes, Your Honor.
Case number 25 CR 121Y, accused of battery from January 4th of this year. And he's got a failure to appear from June 3rd of this year, 25 FTA 1139. He's been advised of his rights, and this is going to be a plea. Mr. Williams, please raise your right hand. Do you solemnly swear?
As the attorney, is that the best way to go?
Judge Law, we've lost your connection. I don't know if you can hear us, but we cannot hear you. Yeah.
It appears that Judge Law may be frozen. Okay, she dropped off. She should be able to rejoin shortly.
I'm sorry, I seem to have a connection issue at that time. Let me go ahead. Mr. Williams, do you swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Nixon, what's the recommendation?
Yes, Your Honor. Recommendation is 12 months to serve 32 days, credit for time served 16 days. That's from June 11th, 2025 until today. Balance probated. No further contact with Tomesia Latrico Pittman. Stay away from 4230 Fulton Industrial Boulevard, Southwest Atlanta. 12 weeks anger management, 40 hours of community service. The state will not process the FTA upon pleading to the underlying offense, and the state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of his plea.
Mr. Massageddin?
I'm sorry, Your Honor, just one moment.
No problem.
Yes, Your Honor, that is our understanding of what the state's offer was. We would just ask, Your Honor, that in lieu of 40 hours of community service, Mr. Williams be asked to pay a $400 fine, and all other conditions remain the same.
Any objection from the state?
No objection.
I talked to him on the phone. He said they're bringing-
Do you so stipulate to the factual basis, venue, and ID, Mr. Massageddin?
Yes, defense so stipulates.
Mr. Williams, have you consumed any medicine or alcohol recently?
No.
Please speak up.
No, ma'am.
Thank you. Have you understood what's going on in your case?
Yes,
And are you satisfied with your attorney?
I am.
If you decide to plead guilty, you would have to give up your right to a trial. You will not go back to court to confront your accuser, challenge the evidence that would be brought before you, and the prosecutor won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? Can't hear you.
Yes.
Your sentence for the battery conviction is going to be 12 months to serve 32 days, credit for time served 16 days. Balance probated. You will report to probation on Monday, June 30th of this year, before 3 p.m. While on probation, at all times, you are to have no contact with Tomesia Latrico Pittman. You are to stay 200 yards away from her and not communicate with her in any way, form, or manner. You are also to stay away from 4230 Fulton Industrial Boulevard in Southwest Atlanta while you're on probation. You will enroll in a program to complete 12 anger management classes, and you must enroll in this program within 60 days of being released. You're also to pay a $400 fine, and you will pay that fine at a minimum rate of $40 per month, plus your probation fees and costs. At all times, you're to maintain the no contact and stay away. You're not allowed to own or possess any firearms during the duration of your probation. Thank you.
Position number 39, Mr. Rowe.
Is Mr. White prepared? Okay. Mr. White, have you had a chance to speak to your other client, Mr. Teatre, was it?
That
Who was the person who didn't understand his waiver of rights?
Mr. Frost, Judge, and we think we're on the same page now, and we can go back to him at some point.
Okay, thank you. Anthony Rhodes is accused of criminal trespass from June 11th of this year, case 25 CR 3294E. Mr. Rhodes, you've been advised of your rights, and Mr. White is your counsel. May I place you under oath? You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
Mr. Nixon?
Yes, Your Honor. State's recommendations 12 months to serve 32 days, credit for time served 16 days. And that's from June 11, 2025 until today. Balance suspended. Stay away from 4120 Fulton Industrial Boulevard, Southwest Atlanta. That's the Budgetel Inn Suites there. The state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of his plea.
Your Honor, we stipulate for the purpose of the plea, nothing further.
Does he need to return to the location for any property?
He did not mention that to me.
Okay.
I have a cell phone, and my flippers that if someone is holding for me.
Who is?
It's a resident.
What's the name?
I actually don't know his real name. I just know
What's the name that you know him by?
Big.
Sorry?
Big.
Mr. Masajidin, what did he say?
Big, Your Honor.
Pig?
Yeah.
His name is Pig?
Big with a B, Your Honor.
Oh, Big. Okay. Good heavens. All right. When you are released, you can contact Mr. Big on the internet and let him know that you need to meet up with him, but you cannot return to the Budgetel.
Yes, ma'am.
Okay, so Mr. Rhodes, I'm sorry, and Mr. White, you so stipulate. Mr. Rhodes, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood what's going on in your case?
Completely.
And are you satisfied with your legal services?
Yes.
If you decide to plead guilty, you would have to give up your right to a trial. You will not go back to court. You'd have to confront your accuser, be able to challenge the evidence that will be presented against you during a trial, be able to present your defenses and arguments, and have the state prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to criminal trespass at the Budgetel Inn and Suites?
Guilty.
Your sentence is 12 months to serve 32 days, credit for time served 16 days, balance suspended. You are required to stay away from 4120 Fulton Industrial Boulevard, which is the wonderful Budgetel Inn and Suites. You are not allowed to return for any property. You can contact your friend Big, and perhaps you can buy him lunch at a different location, and he can return your stuff to you. Thank you.
Thank you, Your Honor.
So my failure to appear didn't show up.
Does he have an FTA? I don't have an FTA case. This is Rhodes. Miss Champion or anyone, if y'all have an FTA on him. Miss Hardy, does he have an FTA in any other jurisdiction presently or a hold?
Bear with me while I confirm.
I don't see any, but
No, Your Honor, I don't see any either.
okay. I don't see an FTA, Mr. Rhodes.
Okay, great.
Failure to appear.
Good.
All right.
All right.
Oh, yeah, he did
Thank
have
you.
one from January 28th. Set.
He told me yesterday. The attorney told me yesterday.
Oh, it's in a felony case, Mr. White. He has a felony hold. It's the felony case is 23.
Yes, Your Honor. I explained yesterday.
Oh, okay. So he does have a felony hold. Do you want the FTA number, Mr. White?
I've got it, Judge. 23
Okay.
SC 188369.
Oh, no, the FTA number is 25 FTA 00.
But that's the case that it's on.
Oh, okay. All right. Thank you.
All right.
Position number 19 and 20, Mr. Malachi Ford.
And Your Honor, I'm going to need to speak with Mr. Ford.
All right,
New position number 37, Thomas
okay.
That's also,
You also need to speak with him?
no. He's ready to go, but it's also my case. So.
Okay, so you have to talk to Mr. Ford, and are we ready to go with your other plea? Mr. Probst, you can have a seat.
Yes, ma'am.
Mr. Frost, you mean, Judge? Yes.
Yeah, okay.
That means.
Probes
Thomas
37.
Probst, we're
Probst.
addressing Thomas Probst right now, and that's going to be case number 25 CR 3307F. Thomas Louis Probst is accused of 4 counts of willful obstruction of a law enforcement officer from June 11th, 2025. Mr. Probst, you've been advised of your rights, and I understand this is going to be a plea. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Nixon?
Yes, Your Honor. For count 1, it'll be 12 months to serve 30 days, credit for time served 15 days. And that's from June 12th, 2025 until today. Balance
It's going to be probated.
Yeah, it's going to be probated. Yeah, I see that now. Balance probated 40 hours community service, $300 fine. As for count 2, it will merge with count 1. The same for count 3 and count 4. They both will merge with count 1. And the state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
Your Honor, we stipulate for the purpose of the plea, just ask the probation terminator go non-reporting once he completes his requirements.
Any objection, Mr. Nixon?
No objection.
All right, that'll be fine. Mr. Probst, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
If you decide to take this plea, you would have to give up your right to a trial in front of a judge or a jury. You will not go back to court to confront the evidence presented against you, to be able to present your own legal challenges and defenses, and the state won't have to prove the charges with beyond a reasonable doubt. Are you prepared to give up your rights?
Yes, ma'am.
How do you plead to 1 count of willful obstruction of a law enforcement officer?
I plead guilty.
Counts 2 and 3 and 4 will merge into count 1. For count 1, it's going to be 12 months to serve 30 days, credit for time served 15 days. Balance probated. Mr. Probst will report to probation on Monday before 3 p.m. That will be June. Yes, sir.
He has another hold. So.
Okay. Then once he has resolved his holds, he will immediately report to probation within 48 hours of being released. While on probation, he will complete 40 hours of community service at a minimum rate of 10 hours per month, and he will pay a $300 fine at a minimum rate of $30 per month. Once his hours are completed, his fine is paid up, and he's up to date with all probation fees and costs, then his probation will be non-reporting.
Thank you, Your Honor.
Can I have clarification on the hold for the felony? Because I believe it was resolved and dismissed the last time I was held, so I just wanted to know if it was the same case that was dismissed for the officer failing to appear 3 times. Thank you for the
There's a failure to appear that's still pending, and you have a hold in a different location.
What was the failure to appear for, Your Honor? I apologize.
I'm trying to look it up, sir.
I've got it, Judge, and I explained it to him yesterday. It's 24 SC 001393.
Give me the
And-
number again.
24 SC 001393. And it looks like there's also a pre-indicted case, 25 PI 004710.
And I have a Cobb County hold, although I don't know if it's still valid. So upon your release, the jail will be able to advise you if the Cobb County hold is still valid. We had a hold from Cobb County that was reported on June 11th, 2025. I'm not sure what that case is.
But the court case is here in Fulton County.
That's the one I'm going to look up. (24SC 001 393). All right, we have 6 charges arising from a traffic incident. Count 1 would be the count 1 and 2 would be the felony charges, and you are scheduled for court before Judge McAfee on July 18th, 2025 at 9 a.m. And this is pursuant to a bench warrant, and there is a motion to set aside the bench warrant scheduled for July 18th.
Okay, thank you very much.
Okay. Ready to go to Mr. Frost, Mr. White?
Yes, Your Honor, still.
I'm trying not to giggle with that name, Mr. Frost, Mr. White in the same sentence, but okay, let's see. So this was Leroy Frost, would that be correct?
That's correct, Judge.
All right, we are resuming the plea hearing for 25 CR 3289Y. And at that time, Mr. Frost was being advised that he has a right to a trial, and the rest of the rights were listed to him, to which he indicated that he was not certain he understood. Mr. White, have you conferred with him?
I have, Judge.
All right, Mr. Frost, do you still not understand what I mean when I say, do you waive your constitutional rights to the trial?
No, I do not.
Okay, so given the rights that I've already listed, do you agree to waive these rights if you decide to plead guilty?
No, I do not.
Okay, so Mr. White, your client does not want to waive his rights to a trial?
Your Honor, I'll have a waiver.
Yes, I do. Yes, I do wish to plead guilty. And I wish to waive my rights. Yes, I plead guilty.
Mr. Massajuddin, are you coaching him, or does he understand what he's saying?
No, Mr. Frost understands what he's.
Yeah. We would be.
Tell me, what rights are you waiving, Mr. Frost?
Just to plead guilty.
Okay. I sincerely cannot accept this plea, Mr. White, because I have a feeling he's just saying words that he thinks will get him out of jail. He has a minimal or inadequate understanding of what he's agreeing to, and I am not accepting this plea. So if you would like to file a waiver of arraignment, I'll be glad to reset this case for trial.
That's what we'll do, Judge.
Next case, you're going to speak to Mr. Ford. Mr. Massajuddin, do you have a case in courtroom 2?
Yes, sir.
Let's do position 16 and 17, Miss Daniel.
Okay. Mr. Bartell?
Hello, is this Mr. Fort?
Oh, I'm sorry, Mr. White, please.
My name's
mute your
Tom
screen.
White. I'm with the Public Defender's Office. Tried to come see you yesterday.
The host, please mute. Mr. White, mute your screen, please. Thank you. Okay. All right. Mr. Bartel, this is your client, Patricia Daniel. How are we proceeding?
But just to clarify, Your Honor, I'm not representing Ms. Daniel. This is a conflict case. When I started looking into it, and I had not discussed the actual facts of Ms. Daniel's case with her, but when I started looking into it, I discovered that the complaining witness is being represented by our office in a pending felony case. So I can't, represent anything about the merits of her case. And I've advised her that she would need a conflict attorney if the state is going to proceed with this case. It is a 2017 case. But I would also let the court know that she has no bond. So if the case is going to proceed, that would need to be addressed.
Understood. Do we have conflict counsel? Any conflict counsel on the Zoom session at the present time? Okay.
That will be signing on shortly.
I'm sorry, Ms. Champion?
Ms. McLeod will be signing on shortly. She has cases on the calendar also.
On the competency calendar?
No, she has cases on the SAT this morning, Ms. McLeod.
Okay. I'll be glad to appoint Miss Maureen McLeod to represent Miss Patricia Daniel. Miss Falk, you have a plea offer as well?
Yes, Your Honor. I can forward that to, I believe Ms. McLeod received that when she received the calendar. She is on the email list.
Understood.
But if she needs me to resend it when she gets in the Zoom, I can do that. Just to let the court know, the failure to appear is what has no bond.
Understood. No,
not the original charge.
Right. The original charge, she had a release bond, but that was from December.
Does just know that he's one.
I do apologize. I had another connection bleep. But as I was saying, if Miss McLeod will appear and she will give you an opportunity to speak with you and see if we can resolve the case today. Otherwise, I will definitely address bond with regards to your failure to appear charge. Okay, thank you. Deputy, we'll have to wait till Maureen McLeod appears. ACDC, may I go to ACDC for the interpreter case?
I don't have an. Oh, she's here. She's here. She's Tom White client. She's here.
Oh, I see. Okay, thank you.
Correct. She's in medical at the Fulton County Jail, Judge.
Oh, she's here in the courtroom now. We have.
Oh, you got it now? Okay.
Okay. Somehow, Deputy, she needs to speak to Mr. White with the assistance of an interpreter.
I'm here, Judge, in the courtroom, and if I can just get put into a breakout room on my laptop here with Mr. White with the interpreter, then that's a way that they can.
Okay, will she be in front of the laptop in a relatively quiet area?
Let me take her this one. Yes, Judge.
Okay. I thought I saw you. There you are. Okay. Miss Grace, Mr. Mirsajudin has a separate Zoom panel under Cyrus Mirsajudin. Do you see it? Our interpreter, is she present? Oh dear. Did we lose our interpreter?
She was on just a moment ago, Judge.
I know.
Yes, she's on.
There she
Yes,
is.
I'm
Miss
here.
All right, Miss Lee, Mr.
Yes.
Mirsajudin, if you can make sure that you put your Zoom panel in the breakout room and then Miss Grace, Mr. White is going to go into a breakout room. And then Miss Lee will have, not Miss Lee, position 38.
And Your Honor.
Miss Chin, excuse me, will have to be in front of your laptop in a relatively quiet area.
Okay, Judge, are they ready?
I think Mr. Masajudin is moving his laptop. Go ahead, sir. Go ahead and make sure your Zoom panel is on your laptop. It's under your full name dash PD. Perfect. Okay. Go ahead and then you will see a message on your screen. Mr. White, you'll get a message also to join a breakout room.
Your Honor, can we do position 36, Mr. David Pitts? And when we finish with him, I'm going to go get the females.
David Pitts is a waiver of arraignment and further notice for trial.
Okay, that's all I needed to know.
Thank you.
Thank you. Okay, it's coming. We gotta wait for that court date. All right, Your Honor. I'll be back with the females.
All right, thank you. All right, I don't know where Mr. Masajudin is going, but I think,
He's gone to the rear of the courtroom.
okay. Courtroom 2, we can take both our attorneys
I don't have anyone available because Mr. Ford is waiting on Mr. White. Mr. Newton, the add-on, he has a private counsel, which is not on yet. And then we're waiting on Miss McLeod, so we still have other people that has to come down.
All right, Mr. Masajudin, do you have any other clients to address in courtroom 2?
Not that are present in the courtroom. I need to speak with Mr. Newton. He was here on Tuesday's SAP calendar. He's supposed to have private counsel, Mr. Render. I informed Attorney Render of that on Tuesday, or at least an employee of his. And I believe that he was emailed about it. He's not here today. Mr. Newton is saying that if he's not here, he would ask for public defender services. So if that's okay with the court, I'll speak with Mr. Newton.
That's perfectly fine. Miss Grace, Miss Champion, I was having some connecting issues. I'm going to reboot and come back onto the Zoom. So we'll be in a 5-minute recess until the PD attorneys are ready to resume. Thank you.
Yeah.
Okay. Deputy, how are we doing so far? Quorum two? Is unmute?
Your Honor, I believe Mr. White should be ready for Ms. Chin's case in just a few minutes.
Okay.
5 minutes.
And you have no other cases right now?
I've spoken with Mr. Newton. He's asked to be represented by the public defender today, so I can proceed with that. That is add-on position 6 and 7. Good morning, sir.
Good morning, sir. And Miss Grace, has Attorney McLeod by any chance made an appearance?
No, ma'am, not yet.
Okay. So we are addressing the add-on calendars 24DF 003493B, State versus Myron Newton. And Mr. Newton has a bench warrant 25 FTA 001131. With regards to the DF case, these are traffic-related offenses stemming from a December 15th, 2022 incident. The charges as accused are driving under the influence of alcohol less safe, endangering a child while driving DUI, driving under the influence of alcohol per se, following too closely, and possession of an open alcohol container. Mr. Newton, you've been advised of your rights. You have waived your right to a private counsel and instead have elected to proceed with appointed counsel through the Public Defender's Office. So Mr. Masarjuddin will be your attorney. And Mr. Masarjuddin, how are we proceeding today?
Your Honor, Mr. Newton intends to accept the state's offer and plead guilty this morning.
All right. Mr. Newton, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. And Mr. Nixon, what is the recommendations for counts 1 through 5?
Yes, Your Honor. As for count one will merge with count 4. As for count 2, it'll be 12 months to run concurrent with count 1 and a $1,000 fine. As for count 3, it'll be 12 months to run concurrent with count 1. As for count 4, it'll be 12 months to serve 30 days, credit for time served 16 days. That's from June 8th, 2025 until today. Balance probated, alcohol, drug, and evaluation treatment, a DUI risk reduction, $600 fine, 240 hours of community service, and 2 victim impact panels. As for count 5, it'll be a $200 fine. And with regard to the FTA, the state will null process upon pleading to underlying offense, and the state would ask that the defense stipulate the venue, factual basis, and identification for the purpose of the plea.
So this should be a total of $1,800 in fines?
Yes, Your Honor.
Count 1 and count 3 will merge with count 4?
Count 1 will merge with count 4. Count 3 is 12 months to run concurrent with count 1.
12 months concurrent to run with count 4. Okay.
Yes.
So he's pleading to counts 2, 3, 4, and 5, correct?
Yes.
Okay. And count 1 will merge. Okay. Got it. Thank you. Mr. Masarjuddin, is that your understanding of the plea offer?
Yes, it is, Your Honor.
And do you stipulate to the factual basis, venue, and ID?
That so stipulates, yes.
All right. Ms. Hardy, is this Mr. Does he have any prior DUI convictions?
No, Your Honor, no prior DUIs.
Okay. Is that your understanding, Mr. Nixon?
Yes, Your Honor. I noted an arrest, but no prior.
But you're requiring a 240 hours of community service?
Yes, Your Honor. That's yes.
Okay. Mr. Masarjuddin, this is what your client has accepted?
Yes, Your Honor, if, Your Honor or the state is amenable to it, we would ask, for a reduction, either in the fines or the community service or both, especially given that Mr. Newton, has advised me, that he did provide proof to his private counsel, Mr. Render, but doesn't have it ready for me now, that he has attended a 30-day rehab program, Sunlight, rehab in Noonan, Georgia. And he did also turn himself in as soon as he was made aware of these warrants, Your Honor. And so, for those reasons, we would ask if the court or the state or both are amenable to reducing fines or community service. We would ask that for Mr. Newton today.
Does the state have proof of this 30-day stint?
Not within our records, but I can check again, but I haven't received that.
Mr. Mirsajudin, has your client ever submitted proof of this 30-day rehab stay?
Your Honor, what he told me was that he had submitted it to his private attorney, Mr. Render, and he doesn't have a way to provide that for me.
Okay, well, the state doesn't have it, we don't have it, so it would be difficult to apply that. Anything else?
Nothing further from the defense.
Okay. Mr. Newton, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with the services of Mr. Mirsajudin,
Yes,
your
ma'am.
attorney? Are you satisfied?
Yes, ma'am.
If you decide to plead guilty to this particular charge, not only would it be over $1,000 in fines, but it would be about 240 hours of community service. And you'll be reporting to probation every month. You will be subject to random screens for alcohol consumption. You're not allowed to consume any alcohol. And pleading guilty to a DUI conviction, with a DUI conviction, your license will be suspended, and I'm going to require a 12-month suspension.
Huh?
Ms. Graves, please mute this iPhone person. Thank you.
Yes, ma'am. So my license suspended as well, in addition to everything else.
Yes, it is. It's not me. It's the state or this the Department of Driver Services. A DUI conviction will trigger a license suspension. And given the fact that, given the information that you were actually in a rehabilitative facility, I am concerned about your alcohol consumption and control of it. So I'm going to require you to not drive for a minimum period of 12 months. Would you still like to move forward with this plea?
Yes, ma'am.
All right. And please understand that if you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial before a judge or a jury. You will not be able to go back to court, confront your accuser, challenge the evidence presented against you, be able to present your own defenses and arguments through counsel, and the state will not have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of endangering a child by driving under the influence of alcohol, driving under the influence of alcohol per se, following too closely, and possession of an open alcohol container?
Guilty.
For count one, that will merge with count 4. Count 2 will be 12 months with a $1,000 fine, and probation will be concurrent with count 1. Count 3, it will be 12 months, probation concurrent with count 4. Sorry, Ms. Champion, for count 2 will be 12 months, probation, $1,000 fine concurrent with count 4. For count 4, DUI per se, it will be 12 months to serve 30 days, credit for time served 16 days, balance probated. You will report to Fulton County Probation on Monday, June 30th, before 3 p.m. While you are on probation, you will pay a $600 fine for the DUI charge. You will complete 240 hours of voluntary community service. attend and complete 2 victim impact panels. You will also complete an alcohol and drug evaluation and submit yourself to any treatment that's required. This must be done within 14 days of being released. You will also complete a risk reduction program. And for count 5, possession of an open alcohol container, that will be a $200 fine. So this will be $1,800 in fines, plus probation fees and costs, and 240 hours of community service. The fines must be paid at a minimum rate of $150 per month. The community service must be done at a minimum rate of 25 hours per month. And your probation will be active for the remainder of the 12 months. You are not allowed to consume any alcohol and no illegal drugs, and you'll be subject to random screens. Your license will be suspended as a result of this DUI per se conviction, and the court will impose a mandatory 12-month license suspension. Thank you.
I believe now, Your Honor, we're waiting on Mr. White to finish with the interpreter client.
Okay, ACDC, I just want to make sure that the folks there are aware. Good morning, my name is Judge Law, and we're going to be addressing each of your cases on a one-on-one basis. Hopefully, all of you have had a chance to speak with an attorney. You do have a right to remain silent. Anything you say in open court about your cases, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Mr. Bartel, do you represent anyone at ACDC?
Your Honor, I would need a chance to speak to Ms. Carter. I believe she's number 12 or 13.
All right.
12, Ms. Carter.
Number 12. Yes, ma'am. I'm in courtroom 2.
Okay, I'll call you.
Okay.
We are ready, Judge, to go on position 30, Ms. Laney. Should be a negotiated plea.
Right. Deputy Milton, to speak with Mr. Bartel, please make sure you dial into courtroom 2 at 22060. You know the number?
Yes, Your Honor.
Okay, thank you, Deputy. All right, this is Miss Laney. And give me the position number again. Oh, got it. Position 30. Okay. And Mr. Mustarjidin, this is your client?
Yes, Judge.
Thank you. This is State versus Denise Shalija Laney, accused of simple battery and battery in accusation number 25 CR 003148G. Ms. Laney, you've been advised of your right to remain silent. Your attorney is Mr. Mustarjidin. And may I place you under oath for the plea? Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes or no? You need to speak up so I can hear you.
Yes.
Excellent. Thank you. Ms. Falk, what's the recommendation?
Yes, Your Honor. On the simple battery, state's recommendation is that count 1 will merge with count 2, which is the battery offense. On the battery offense, 12 months served, 180 days, credit for time served, 24 days from June 3rd, 2025 until today. Balance probated, 12 weeks of anger management, no further contact with Shantaria Rainey, and 80 hours of community service. At this time, we would like to sound for Shantaria Rainey. And we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
Defense so stipulates.
Thank you. Shantaria Rainey, if you're on Zoom, this is the time to unmute and start your video. So she would have 33 more days to serve at the jail?
I believe that's correct, Judge.
Thereabouts. I'm not. I'm relatively comfortable with the math, but I'm very open to any corrections. Okay. All right. And Miss Laney, have you consumed any medicine or alcohol recently? Miss Laney, I appreciate your soft spoken, but this is the time to speak up because
I take medicine.
okay. And after consuming your medication, are you still able to understand what's going on? Just one second. Mr. Masarjuddin, if you could, thank you. I'm so sorry, Miss Laney, we had some background noise.
Yes, ma'am, I understand.
Are you still able to understand what's going on in your case and today?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And if you decide to plead guilty to these charges, you would have to give up your right to a trial in front of a judge or a jury. You will not go back to court to face your accuser, to challenge the evidence brought against you, present your own defenses and arguments, and the prosecution won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
No, ma'am.
So you do want a trial then?
No.
Has your attorney explained to you that in order to plead guilty, you would have to give up your constitutional rights, as I've just listed?
Yeah.
It's okay to say, I don't know, or I didn't understand. It's okay. You will still get a chance to speak with your attorney.
I don't remember.
I'm sorry?
I don't remember.
Repeat the response.
I said I don't remember.
You don't remember. That's perfectly fair. We will give you a chance to speak to Mr. Masarjuddin, and he will re-explain to you so that you understand what you're agreeing to. Okay?
Yeah.
All right. Let's see. Deputy Milton, if you are present. Mr. Masarjuddin, when Deputy Milton speaks to Mr. Bartel, please remind her that you need to speak to Miss Laney. Please unmute.
Yes, Judge.
All right. Who do
Mr.
we have?
Bartel, I believe, is ready.
All right. Who do we have at ACDC? Mr. Bartel, is that your client?
Ms. Carter, yes, we can proceed with Ms. Carter. That's position 12, and that's a negotiated plea.
All right. And Deputy Milton?
Yes, Your Honor.
Miss Laney will need to speak to Public Defense Attorney Masarjuddin in courtroom 2.
I'm on the phone with him right now.
Thank you. This is Cambrielle Carter, position number 12 on the calendar, accused of criminal trespass from June 7th of this year. Ms. Carter, your case number is 25 CR 003302G. Ms. Carter, you've been advised of your rights, and your attorney is Mr. Bartel. May I place you under oath? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Speak up, please.
Yeah.
Thank you. Ms. Falk, what's the recommendation?
Yes, Your Honor. And just to make sure I'm on the right page, this is Ms. Carter's case.
Cambrielle Carter.
Cambrielle Carter, position 12. Okay. The state's recommendation is 12 months served, 30 days, credit for time served, 15 days. That will be from June 12th, 2025 until today. Balance suspended. Stay away from Terrence Hatch, located at 9250 Wilkerson Mill Road in Chattahoochee Hills. And that would also be a no further contact with Terrence Hatch. We do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea.
And
that's all for the state.
And we do so stipulate, Your Honor.
Anything else?
Nothing from defense, Your Honor. We would just ask the court to accept the agreement.
Ms. Carter, have you consumed any medicine or alcohol recently? Speaker?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with Mr. Bartel's services?
Yes.
If you decide to plead guilty to criminal trespass, you will have to give up your right to a trial. You will not go back to a courtroom. The prosecutor you will not be able to challenge the evidence presented against you. You cannot present your own arguments and defenses, and the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of criminal trespass? Repeat.
Plead guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days, balance suspended. If you have no other cases holding you at the jail, you will be released within 24 hours. However, you are to have no contact with Terrence Hatch, and you have to stay away from 9250 Wilkerson Mill Road in Chattahoochee Hills, Georgia. If you return to that property, you will be arrested again, and we get to do this all over.
Okay, I have a question.
Understood?
Yes, I understand. But what if I wanted to open up another case to against Terrence Hatch?
You would have to hire an attorney, or you can file a civil case in the appropriate court, but you yourself cannot communicate with Mr. Hatch, and you have to stay 200 yards away from him. When you go to court, you need to let the judge know that you have a court order requiring you to stay away from him.
Thank you.
Understood?
Yes.
Thank you.
Thank you.
Position 30.
All right, we are resuming with position 30, 25 CR 003148G. We're in the middle of the plea colloquy, and Miss Laney, I was telling you that if you decide to plead guilty to simple battery and battery, you would have to give up your right to a trial. You will have to give up your right to going back to a courtroom to confront your accuser, be able to challenge the evidence brought against you, and the prosecutor won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to simple battery and battery?
Yes.
Your sentence for the battery charge, count 2, is going to be 12 months to serve 180 days, credit for time served 24 days. You have 33 more days to serve at the Fulton County Jail. After this additional time is done, you'll be placed on probation. You'll report to probation within 48 hours of being released. While you're on probation, you will enroll and complete 12 anger management classes. You will complete 80 hours of community service at a minimum rate of 8 hours per month. And you are to have no contact with Shontaria Ramey. You have to stay 200 yards away from Miss Ramey and not communicate with her in any way, form, or manner. Thank you.
Next is position 47 and 48. Ms. Tribble.
This is State versus Annie Tribble. Ms. Tribble's case on position 47 is 25 CR 3336J, in which she's accused of battery, simple assault, and simple battery from a June 12, 2025 incident. Ms. Tribble has a second case, position 48, in which she's accused of battery, family violence, from a March 15th, 2025 incident. And case number 25 CR 1407J. Ms. Tribble, you've been advised of your right to remain silent. Your attorney is Mr. Massajuddin. And this is going to be a plea, Mr. Massajuddin?
No, Your Honor. Ms. Tribble, we will waive arraignment and plead not guilty today. We are asking to be heard on bond for Ms. Tribble.
All right. Just give me a moment to pull up the case. All right, on position 47, Ms. Tribble received a $2,000 good bond. And so I guess that's 1,500 and 500. Okay.
Yes, Your Honor issued that on June 14th of this year.
All right. And her signature bond in her other case has been withdrawn. I think it was, I don't remember the amount.
It was surrendered by pretrial services. That amount was, it looks like a $2,000 signature bond through pretrial services that was surrendered
All right.
and converted to a $2,000 surety bond.
So Ms. Tribble currently has a $4,000 surety bond on both cases. And Ms. Tribble has got 58 cycles. And that's all I recall. Anything else to add, Ms.? Oh, well, let me see what Mr. Mirzadin wants.
Yes, Your Honor, we're asking for Ms. Tribble to receive signature bonds on both of these two cases. We understand she was already granted a signature bond and had that surrendered by pre-trial, but Ms. Tribble is a lifelong resident of the city of Atlanta. All of her family resides here, including her children and grandchildren, Your Honor, and she receives Social Security as her income. She gets a check on the first of the month. Your Honor, she is at risk of losing her apartment and all of her possessions that are contained inside. Your Honor, she is not able to make bond until she gets this check on the first. And that would be too late for her to maintain her current living situation, Your Honor. So we're asking for Ms. Tribble to hopefully prevent her from becoming homeless. Your Honor, that she receive a signature bond on both of these two cases before Your Honor this morning.
So where would she be living?
She does have an apartment, Your Honor. It is it's listed as the incident location on position 47, the case ending in 3336J. That is at 339 Holly Street in Atlanta. She resides in apartment 205. The alleged victim resides in apartment 203. Ms. Tribble does intend to move once her lease is up there, but that is her current place of residence. She resides alone there.
So 339 Holly Street, apartment what?
205.
All right. Ms. Champion, on position 47 and 48, her address has to be amended to include apartment 205. And in that particular case, she was already granted a signature bond, no violent contact with Gabriana Glass. And then right after less than 3 months, less than 3 months, she's now required to stay away from Holly Street because now there's another encounter with another, neighbor?
Allegedly, yes, Judge, a neighbor.
So why am I letting her go back to the same location? I understand housing, but apparently Ms. Tribble has been unable to avoid situations of violence.
Your Honor, that is her only place of residence that she can stay at the moment. She does intend to move away from there as soon as she possibly can, Your Honor, but she lives on a fixed income. She can only work with the resources that she has available. She's still waiting to receive her check on the first on Monday or on Tuesday, Your Honor. But we are just trying to prevent her from losing her current residence and all the possessions.
I understand that, Mr. Mirzadin, she was given that opportunity in March when she was given a signature bond and told to have no violent contact with her neighbor and to avoid getting arrested. I'm still trying to grasp the rationale of why I'm allowing her back to that community.
Your Honor, we're just begging for the court's mercy for Ms. Tribble to not lose her place of residence.
Ms. Falk?
Yes, Your Honor. The state's main concern here is that, well, one, she has an extensive history that does include violence. Two, she did get into an incident involving her granddaughter. Then it appears relocated from the address where she was staying at back in March at Fisher Road to the new address at Holly Street, then got into an altercation with her neighbor, punched her in the face, hit her with her cane, which is what she was alleged to have done to her granddaughter. She was alleged to have hit her multiple times with her cane. And then when the police tried to arrest Miss Tribble on the second case, she spit at the officer. Your Honor, I understand she is a, woman who is of advanced age, but she's a bit of a menace. She has got a lengthy history and doesn't seem to stop getting into altercations with people, including police officers.
Nice to believe.
Anything else, Mr. Masarjanin?
Your Honor, we would just acknowledge Ms. Tribble's extensive history. Does maintain, I believe, 56 cycles or 58 cycles, Your Honor, but we're unsure of how many of those led to convictions or fully prosecuted. She has a history of run-ins with the law, Your Honor, but we're not sure about actually being convicted of these things. She's presumed innocent, of course, on these charges as well at the time, Your Honor. The ultimate purpose of bond is to secure Ms. Tribble's presence in court for her next court date. Your Honor, we understand that she does have the history and that the court may be concerned about a risk to reoffend, Your Honor, but we would maintain that the primary purpose of bond is to secure her appearance at her next and all future court dates. And we didn't hear any history on there may be about failure to appear, but we would just ask that Ms. Tribble be granted a signature bond on these two cases before the court this morning.
And
I'm sorry, go ahead.
Just to answer PD Masajidin's question, 9 convictions in the last 10 years. So about 1 a year.
My concern is not her ability to return to court. My concern is her ability to prevent reoffending. That is one of the pivotal Ayala factors that I'm just not comfortable with. I'm going to keep the same bond. I don't see any undue change of circumstances. I do understand that she is older. I do understand that she has limited income, but the overriding factor is that Ms. Tribble apparently has anger management issues and a sincere inability to incline towards violence. Bond modification denied.
Your Honor?
Yes.
I'm going to have to take these ladies back and bring Miss add-on position 5 with Natasha McClendon when Miss McLeod is on the Zoom.
Okay, I appreciate it. We can still address the other cases on the calendar. Thank you. We'll see you soon.
Hold on a second, please. I'm gonna, if Courtroom 2 will call me and let me know when she's ready. That will help me out a lot.
Okay, thank you.
Thank you. Let's go.
Your Honor.
Mr. White, are you ready to address your interpreter case?
Yes, so she's going to be a waiver, and I guess just so that we can let the interpreter go.
Okay. Have you explained the waiver to Ms. Chi?
Yes, Judge.
Okay. I don't know if they've come out of the breakout.
They are out of the break. I believe they've already removed Ms. Ken from the room. So, and I see the interpreter in the gallery view.
Miss Interpreter Lee? Interpreter Lee? Miss Ying Lee? Oh, will the host please prompt Miss Lee to unmute?
Okay, Judge.
Miss Lee, can you hear me?
Yes, one moment. Let me adjust my volume. Can you hear me okay, or,
Loud and clear.
oh, you can hear me okay?
Yes, I understand that a public defense counsel, Mr. White, is going to enter a not guilty plea on behalf of his client. So the
Yes.
case is going to be further notice for trial. Thank you so much for being here.
Okay, thank you very much.
You're free to go.
Okay, thank you.
Position number 19 and 20, Mr. Ford, Malachi Ford.
That's going to be a negotiated plea, Judge.
Thank you. I've got position 22, is that correct? 22 and 23, is that correct?
Judge, there are a couple of different calendars floating around.
Okay, let's go with, I'll just go with Malachi Ford. Are you Mr. Malachi Ford?
No.
Yes, no?
Yes, ma'am.
Okay. Mr. Ford has two cases on the calendar, 25 CR 807B, accused of 2 counts of criminal trespass from January 12th, 2025 and January 25th, 2025. He has also a bench warrant, failure to appear, 25 FTA 1143 from April 14th, 2025. Mr. Ford, you've been advised of your right to remain silent. Your attorney is Mr. White. And is this going to be a plea?
It is, Judge.
Okay. Ms. Falk, what's the recommendation for Mr. Ford?
Yes, Your Honor. The recommendation is 12 months served 32 days, credit for time served 16 days. On February 15th, 2025, and then June 12th, 2025 to today, balance suspended, stay away from, actually, we have had a chance to talk to the victim and we are removing the stay away and the no further contact provision and modifying to no further violent contact with Kiera Harrington. Count 2 will merge with count 1. The second case, which is the failure to appear, the state will null pros upon acceptance of this plea. If Ms. Harrington is here and would like to speak, now is your opportunity. We do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. That's all for the state.
Your Honor, we do stipulate for the purposes of the plea.
All right. I have a Kiera Marie. Are you Miss Harrington?
Yes, I am, Your Honor.
All right. Do you want to say anything?
Yes, I would. I would honestly, oh, I'm
Raise your
sorry.
hand. Other right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. What would you like to tell us?
Yes, I honestly would ask the state to drop the charges or either something less, because what's in the police report, that's not what happened. I didn't call the police trying to press charges or anything of that sort. I was honestly calling the police because my front door was messed up. That's what happened. Had an altercation. We were arguing. He left out of the house and I guess he was doing his last big final gesture and he kicked the front door. And that's when it came off of the hinges. My door was previously damaged. I explained this during the bail hearing. I explained all of that to them, but we're still here. Like I stated, I didn't call the police to press charges. That was my first time ever calling the police. We've been together for 1.5 years. So I just kind of asked for some leniency. If not, if we're able to drop the charges, because again, I wasn't calling as far as for him. I was just calling because I didn't have a front door at the time.
And Ms. Kiera Marie has very helpfully, Ms. Harrington has very helpfully laid out the state's elements of proof for the criminal trespass. So, Your Honor, we ask to move forward with this plea.
Ms. Harrington, I understand that you don't want to press charges, but the ultimate decisions with the prosecutor, sometimes they can attempt to prove a case against the defendant without the victim's input.
Understand.
However, based upon your sworn testimony, it appears that you yourself have established the necessary facts that the state would need to prove a charge of criminal trespass causing damage to property against Mr. Ford.
Understand.
So I understand that you do not want to press charges. The state still would proceed if Mr. Ford decides not to accept the plea At this time, then I will ask his attorney, Mr. White, does your client still want to move forward with the plea, given the reluctance on the part of the alleged victim?
I believe he does, Judge.
Okay. Thank you, Ms. Harrington. All right, Mr. Ford, you've been sworn. Have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am, I am.
If you decide to plead guilty to this charge of criminal trespass causing damage to property, you would have to give up your constitutional right to a trial. You will not go back to court to face a judge or a jury to be able to challenge the evidence and the testimony brought against you. You will not be able to present your defenses and arguments, and the state won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass causing damage to property?
Guilty.
Your sentence is 12 months to serve 32 days, credit for time served 16 days, balance suspended, no violent contact with Kiara Marie Harrington. Thank you.
Thank you, Your Honor.
And count 2 will merge with count 1. The bench warrant will be dismissed. All right, Ms. Harrington, you're free to go. Courtroom 2, do we have another case to address?
Yes. We can do. Well, Ms. McLeod not on yet, right? So we can do position number. Let's do number 1 through 3.
I need to speak with him.
Okay.
All right.
Let's do number 13. Anybody need to speak to him?
I've already spoken to you.
Come on, number 13.
All right, Mr. White, if you please call the jail. This is State versus, sorry, my staple is right on that. I'm sorry, Mr. Bartel. I've just got bad stapling techniques and I've just stapled right over Peter's last name, so.
Mr. Chesnikov.
Chesnikov, okay. Peter Chesnikov is accused of loitering and prowling, and his accusation number for this particular case is 25 CR 3314G. Incident date appears to be May 26, 2025. Mr. Chesnikov, you've been advised of your right to remain silent, and your attorney is Mr. Bartel. This is going to be a non-negotiated plea. Mr. Chesnikov, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am. Yes,
Thank
Your Honor.
you. Ms. Folk? I'm sorry, you're muted?
Thank you, Your Honor. This case is a loitering and prowling case that occurred back on, let's see, May 26th of 2025. State's recommendation is 12 months served 60 days, credit for time served 15 days. That will be from June 12th of 2025 until today. We also are requesting a stay away from 13410 Hopewell Road in Milton, and no further contact with the victim, Flor Casito. This incident occurred at about 12:50 p.m. The officers went to the location, spoke with Ms. Casito, who stated she was inside her home when she noticed the defendant on her property. He looked inside of her vehicle, around her property. He then physically attempted to open the door to her home. At that point, she called police. She explained she told him to get off her property and that she was calling the police, and she noticed that he had a dog treat and claimed it was for her dog, which was inside. She pointed out the dog treat to the officer that was laying on the ground. She also stated that the defendant had left at that point by the time police arrived. Miss Flor said he was traveling southbound on Hopewell Road. They did take him into custody and found he was holding a dead snake. When they located him, he informed the officer that he threw the defendant then threw the snake on the officer's vehicle when he approached and said it was fresh roadkill and he was going to skin it. He also claimed he went to the door because he needed water. However, he gave conflicting statements as to where he was living. The reason these states offer for the jail time is mainly due to the fact that the defendant tried to enter Miss Casito's home and had a dog treat for her dog, which just appeared to be as though he was trying to enter her home and maybe distract her dog from whatever he was doing. The state just really has some concerns about this fact pattern, and just really it feels very problematic given all of the circumstances. We do ask the PD's office stipulate to venue, factual basis, and identification for this non-negotiated plea. That's all for the state.
Mr. Bartel?
Yes, thank you, Your Honor. We would so stipulate to those factors for the purposes of the plea. Of course, you know, the non-negotiated aspect is we are asking the court to just sentence Mr. Chesnikoff to time served, which will be 30 days credit for time served. He has been in the Fulton County Jail for 15 days. I am advised that he's been diagnosed with bipolar, Your Honor. I discussed with him his options. I believe he understands very well what his options are and how this process operates. Be that as it may, he was going through a very difficult time. He was going through a very difficult time when this incident occurred. The incident date is May 26. From the police report, it indicates he was 1013 to North Fulton Hospital. He indicates that he was hospitalized subsequent to that. I haven't been able to confirm this, but it appears that he went right to Fulton County from whatever facility he was at. So he's actually been in custody in one form or another for a month right now, since May 26. And I hear what the state is saying about the dog tree. I think given what was going on, I really do think there was something less sinister than that happening. So given all of that, we would ask the court to just accept his guilty plea. We certainly would agree with the no further contact, stay away. We would just ask that his sentence be 30 days to serve and balance suspense.
And Your Honor, we would like to sound for Miss Casito if she is here today.
All right. Miss Casito, Flor Casito, if you're on Zoom, this would be the time to unmute and start your video. All right. Based on the information, reading the warrant, I can honestly tell you I did not do the first appearance. Otherwise, I'll definitely remember the dead snake part. But Mr. Bartel, I would agree to serve 30 days, credit for time served 15 days, balance probated for him to continue with either MH treatment and compliance, or undergo an MH evaluation and continue with treatment and compliance. No pets, dead or alive, for a minimum period of 12 months. I will waive the probation fees for the first 6 months. And then after that, he'll need to continue paying probation fees and be compliant with all MH treatment and medication.
Okay, I will discuss that with him, Your Honor, if I could have a second.
All right. Don't forget the no pets part.
Very well, Your Honor. That is in my notes.
All right. Thank you.
We can
Mr. Masarjadin, are you ready to address any cases while we wait?
Williams. Position 51, Williams, Michael Williams.
This is State versus Michael Angelo Williams, accused of battery, family violence, cruelty in the third degree, 2 counts from a May 31st, 2025 incident, accusation number 25 CR 003119E. Mr. Williams has been advised of his rights. His attorney is Mr. Masarjadin, and Mr. Williams, may I place you under oath? Do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Okay, this is going to be a non-negotiated plea. Ms. Falk?
Yes, Your Honor, this is position 51.
Yes.
The state's recommendation on this case, Your Honor, is 12 months on count one, the family violence battery, 12 months served, 90 days, credit for time served, 26 days, balance probated, FVIP, no further contact with Samaya Burton, stay away from 8060 Adair Lane in Sandy Springs, and no firearms. Count two would be 12 months concurrent with count one and 40 hours of community service. Count three would be 12 months concurrent with count one as well. The reason for the state's recommendation, Your Honor, just to give Your Honor a little bit of the factual basis here, this incident happened on May 31st of 2025. And the incident occurred at 8060 Adair Lane. The officers spoke to a child who had called 911 advising that his mother had been shot. Upon arrival, the officer spoke to Miss Burton. She had a large laceration on the right side of her head. A substantial amount of blood was pouring from her head and pooling onto her shirt. The right side of her head was extremely swollen. She then when they talked to Miss Burton, she stated she had been struck by the defendant, who then fled the location, and she advised her two children were inside. The children were reunited with Miss Burton. The officers then pulled the information and determined, because she first gave the name, I believe, MB, and they were able to pull the information and identify the defendant. They did speak with a child, AB, who was the one who actually called 911. He stated he saw the entire altercation. He stated his mom and the defendant were arguing over the keys to her car. At one point, the defendant struck his mom in the head, who then fell to the ground. He then stated the defendant ran past him toward the door and exited. The officers noted in their warrant and in the report that the child appeared to be in a lot of emotional distress and was showing a lot of fear. And so the state does have some really serious concerns based on what occurred both to Miss Burton and to the child who was present. This defendant is a multi-state offender. He has 3 cycles out of, I believe the state is Kansas, one of which is for aggravated assault. That case was from 2023. It was aggravated assault with a deadly weapon. And in the notes, it says this is a domestic violence case, use of a deadly weapon. There is also a second cycle that was dismissed. That was a domestic battery in 2021. It said in the notes, this is a domestic violence case, and they call it rude physical contact with a family member or a dating relationship. And in 2022, he entered a plea and received 6 months with 30 days for brawling or fighting. And that was his history outside of the state. And then he has this new case. That was the basis for the state's recommendation as to the 90 days. Ms. Burton also sent us some screenshots of her injury, and that was also part of the basis for the state's recommendation as well. And I can put those screenshots up if Your Honor would like to see them.
What? No, that's not necessary. Anything else, Ms. Falk?
Nothing, Your Honor. If Ms. Burton is here, we would like to sound for her. I will state, as with many domestic violence victims, she no longer wishes to prosecute, but based on the defendant's history and this new offense, the state is disinclined to, is going to move forward on this case.
Okay. Ms. Burton, I do see you on Zoom. If you want to address the court, please lower your hand and raise your right. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, please pick up your device and put it. Okay, perfect. Thank you. What would you like to tell us?
As far as the cases, well, the cases that she just presented, I've been present in Michael's life for quite some time. The aggravated assault case, that was dismissed. It was only because we lived by a school. That case is not, that's the facts that she's stating on these cases isn't true. I've never sent any pictures of myself to anyone, so that is a little concerning as well.
No, this would be probably pictures from the police officer's body cam.
Okay.
So,
Okay, maybe that's different because she did state that I personally sent them.
Okay,
So,
and my
that-
apology, Your Honor, Miss Burton, there were actually screenshots from when she was here in SEA and had a very clear injury to her head, which had been bandaged.
all right, thank you.
Okay. Okay. But yeah, and then like I have been requesting since the very beginning, as far as the no further contact, we share a child together that's not even in school. He's a minor child. As the no contact, I don't agree to the no contact. Like I said, if he has to do anger management or things like that, that's fine. But as far as no contact, no, he's not a violent person. And those other charges, I don't even know if that is even him, because I've never heard of those charges. I don't think he has either.
Well, why, I'm sorry. So you haven't heard of those charges or you're not?
No, he's
Oh,
never been in.
No. You've never heard of these charges? Hello, where are you? Okay. Or have you ever run his criminal record history yourself?
We did when we was in Kansas. He was in the military.
So you ran his criminal record history?
When he was in the military, that's what I'm saying. He just got out the military. He's never.
I'm asking you, have you personally seen his criminal record history?
Yes, when he was in the military. Yes, I've
Which
stated
was
yes 3
this
times.
year?
No, this is the first charge he's had in some time. He has not been arrested for none of
So
those charges.
he's never been arrested in Kansas for aggravated assault.
He was, and it was dismissed. He was arrested due to living by a middle school with a gun. Yes.
Prior to that, he was never arrested for alleged rude behavior to a victim.
Yes.
He was not arrested?
He was arrested. I say yes.
And this one on May 31st, 2025, when the police reported to your home, you did not identify him to the police?
Yes, I did.
Continue.
Right. So again, I stated all charges that she stated. I didn't say that he's never been arrested. Some of those charges are not, the facts on the charges is what I stated. The facts of the charges are not correct. So I'm considered to be the quote unquote victim in the other cases as well. The facts of those cases are not correct. That's what I'm getting
Let's focus
at.
on the case presently then.
Even my child being terrified and things like that, my child, he did some evaluation through DFACS. They determined he's not whatever, they traumatized, he's not any of that. My child truly misses him. Crazy, cries for him. This is the 9-year-old that they're referring to. Cries for him to be around. He's not traumatized at all. As far as the child I share with him, the 3-year-old, he thinks his dad is deceased because he hasn't seen him yet. So no, my kids are not in fear of him. Yes, it was a scary moment because it was something that never happened before within the 5 years of knowing him. So yeah, it was a scary moment at the time, but my kids are not traumatized. So I would really like if everybody stopped the narrative. They're not traumatized at all.
Thank you, Ms. Burton. Mr. Jadin?
Yes, Judge. As for Mr. Williams, the only things that we are asking to be altered as far as the state's initial offer was that he do be allowed to have contact with Ms. Burton. It can be a no violent contact provision, and that Mr. Williams, the state is currently recommending that he serve 90 days with credit for time served 26. We would ask that he be given 60 days to serve and 26 days credit for time served.
All right. On the count 1, battery, family violence, if Mr. Williams decides to plead guilty, the court will accept the state's recommendation with the modification of no further violent contact with Samaya Burton. He has to stay away from 8060 Adair Lane in Sandy Springs or wherever Miss Burton lives with the 2 children. He cannot cohabitate with Miss Burton and the two children. In order to have contact, he must file a legitimation action within 60 days of being on probation and obtained a court order to establish court-ordered visitation and custody, as well as child support or whatever else Miss Burton would like to have. Within 60 days also, he must surrender any and all firearms that are registered to him, and they must be surrendered to the authorities for destruction. This is non-negotiable. He's not allowed to own any firearms, and he must surrender any and all firearms registered to him within 60 days to the police authorities and provide proof to probation that they have been surrendered and destroyed. He will enroll in the Domestic Violence Intervention Program within 30 days of being released, and he will attend and complete all 26 classes without missing or skipping any of them. Right? He's not to consume any illegal drugs and no alcoholic beverages, and he'll be subject to random screens for alcohol and or illegal drugs. Count 2 would be concurrent with count 1, and he would need to complete the 40 hours of community service at any nonprofit agency. Within 30 days of being released and placed on probation, he must provide the court and probation with his new residential address, since he's not allowed to reside with the alleged victim and the children. So, Mr. Jardin, this would require him to serve an additional 19 days and then do what's required.
Yes, Judge, can I have just one moment to make sure that Mr. Williams understands all the conditions?
Okay, thank you. All right, ACDC is not on. Miss Maureen McLeod, are you by any chance on Zoom? Okay. Do we have any DV bench warrants, Miss Folk?
No, Your Honor, just the competency calendar.
Okay. Miss Champion, any updates on Miss McLeod?
I will check, Your Honor.
Otherwise, if we have any other defense counsel who are available, Ms. Zakia Watson Crew or Mr. Dennis Murphy?
Just to let the court know, I've talked with Mr. Chesnikoff, number 13, and he's willing to accept the court sentence.
All right. All right. Mr. Masar-Judin, Deputy, can we have them confer separately, and I'll address Mr. Bartel's position, which is position 13. Sorry, Miss Greenhouse, we seem to be doing a boomerang, but probably okay.
That's okay, Your Honor. I think I'm with you with everything.
Thank you.
Thank
All right,
you.
Resuming the case with position 13, I have case 25 CR 3314G. This was a non-negotiated plea. The court is, as I've indicated, the court is would amend it to serve 30 days, credit for time served 15 days, with 12 months reporting on probation, MHET, and no pets.
And he's willing to accept that, Your Honor. We've talked about a plan for getting an evaluation and following whatever recommendations. He has health insurance.
All right. Mr. Chesnikoff, you've been sworn. Have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, Your Honor.
If you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not be able to confront your accuser, not be able to challenge the evidence and testimony brought against you, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to loitering and prowling from May 26, 2025?
Guilty.
Your sentence is 12 months to serve 30 days. Credit for time served 15 days, balance probated. You will report to the Fulton County Probation Office on Monday, June 30th, before 3 p.m. While you are on active probation, within 30 days, you will enroll and complete an MH evaluation and submit to all treatment and medication that's required. You will continue with ongoing compliance with MH treatment and medication while on probation. You will stay away from 13410 Hopewell Road in Milton, Georgia. That is 200 yards away from that location. You're also to have no contact with Flor Caicedo, Caicedo. You're also not allowed to own any kind of animal or pets dead or alive. I don't care whether it's an insect all the way to an elephant. You're not allowed to own any type of animal. Do you understand?
Understood, Your Honor.
All right. Your no illegal drugs, no alcohol, and your first report date's on Monday. Thank you.
Thank you, Your Honor.
Excuse me, Judge, Ms. McLeod is about to come on.
Thank you. And Mr. Bartel, was that Patricia Daniel? Oh, yeah.
Yes, ma'am, that's Ms. Daniel.
Position, is she still in the courtroom?
She is, Your Honor.
And I'm sorry, who are we addressing presently?
This is position 54, Williams Francois.
54.
And Your Honor, this is a negotiated plea for Mr. Williams Francois.
Thank you. Tequan Williams Francois is case 25 CR 3308F, accused of criminal trespass and loitering and prowling from April 30th of this year. Mr. Williams Francois, you've been advised of your rights, and your attorney is Mr. Mercer Jadid. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Nixon?
Yes, Your Honor. As for count one, it'll be 12 months to serve, 30 days, credit for time served 15, and that's from June 12, 2025 until today. Balance probated, stay away from all Georgia Tech properties, and no further contact with Jolie Claudio. As for count two, 12 months to run concurrent with count one, anti-theft course, and 40 hours of community service. The state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
And defense stipulates that is our understanding what the state's offer was. Mr. Williams Francois does intend to plead guilty this morning.
Okay, thank you. I'm just going to take a brief pause on Mr. Williams Francois. Good morning, Ms. McLeod.
Good morning, Your Honor.
We have a case requiring conflict representation. This would be Patricia Daniels, and she is position 16 and 17. There is a plea offer. I think it's listed on the calendar. Do you have it?
I have the calendar, Your Honor.
Do you have the one with the state's plea recommendations?
I will take a look.
Okay.
And Your Honor, I apologize for being so late, but I was held up in Judge Edie. I just got done.
Oh, no, I would never find any objection with that. Trust me, it's okay. But in the meantime, if you have the plea offer, Miss Daniels in courtroom 2, and the phone number to reach there is 404-612-2060. 612-2060.
2060.
Correct.
I have it, Your Honor. I will call.
Appreciate it. Thank you. Okay, returning to Mr. Williams Francois. So stipulated by the defense. Mr. Williams Francois, have you consumed any medicine or alcohol recently?
Okay.
Have you understood what's going on in your case?
Yes, ma'am.
I'm sorry, please speak up.
Yes, ma'am. They're going to transfer Ms. Daniels.
Okay, just one second. Let me get.
My apologies, Your Honor.
No problem. Okay. And are you satisfied with your attorney? If you decide to plead guilty to these two charges, you would have to give up your right to a trial. You will not be able to go back to court to face your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights? I'm sorry, Mr. William Francois, are you prepared to give up these rights?
Yes, ma'am.
I'm sorry, background noise. But can you hear me all right, Mr. William Francois?
Yes, ma'am.
For criminal trespass, count 1, the sentence is 12 months to serve 30 days, credit for time served 15 days, balance probated. He will report to probation on Monday, June 30th before 5 p.m. At all times while on probation, he is to stay away from all Georgia Tech property. He cannot be at any of the properties owned by the Institute of Georgia Technology, and he's to have no contact with Jolie Claudio. For count 2, loitering and prowling, it's going to be 12 months concurrent with count 1. Within 30 days, he must enroll in an anti-theft course and complete the class. And he's also to complete 40 hours of community service with any nonprofit agency that's not a church and not a school. And he has to do his community service at a minimum rate of 5 hours per month. Thank you.
The person who's stating that they own the.
Anything else, Mr. Masajidin?
No, Your Honor, nothing from defense.
Okay, thank you. It completes his plea.
Let's go to number 22, Jenkins.
Okay. Give me that. Did you say Akpan Jenkins?
Yes.
Okay, that's position 29. Would that be correct?
22.
Okay, I'm just going to go by the updated calendar, but we are with Akpan Jenkins, case number 25 CR 003317C. Mr. Jenkins has 2 counts of abandonment of a dependent child from January 24th, 2025.
Your Honor, if I may, Mr. Jenkins requires representation from a conflict attorney. It's my understanding that my supervisor, Mr. Haddad, did send out the paperwork on the 20th of this month. I'm not sure if that has all gone through or if Ms. McLeod is prepared to represent Mr. Jenkins, and she will be the conflict attorney, but he is not a public defender client or a full-time public defender.
Yeah, that he's going to be
All right. On these 2 counts, his purge amount is $387. Is that the amount he's going to pay on probation?
He's gonna be.
Mr. Jenkins?
Yes, ma'am, they told me I had to pay a purge of $387, like you just said, and they will release me from here. That's what they told me 2 weeks ago.
Okay, that doesn't answer my question. So I am going to let Ms. McLeod, as soon as she's done talking to Ms. Daniels. Mr. Masajudin, could you please advise that she needs to stay on the line and
Yes,
speak to Mr. Jenkins? And the offer is basically 12 months with the time that he served, balance probated, and to pay that $387 on probation.
Okay.
And concurrent with count 1 for the second charge. Okay, so we'll come back to Mr. Jenkins once he speaks to Ms. McLeod.
This is arraignment non-guilty. 1, 2, 3. Yeah, 1, 2, and 3. So we don't need them.
We don't need him?
Yeah. Right, that's what Tom said. Let me double check.
I'm sorry, Mr. Masajudin, the gentleman seated next to you, is that a waiver?
I need to double check with Attorney White, but I believe, yes, it is a waiver of arraignment not guilty for positions 1 through 3.
That's correct.
We can do position number 35, Patterson. Come on, Patterson.
Okay. Positions 1 through 3 is a waiver of arraignment and further notice for trial. Sorry, Deputy, who's the name? What's the name?
David Patterson, number 30.
Okay, thank you, thank you.
Okay.
David Bernard Patterson is accused of criminal trespass and simple battery under case 25 CR 3081G from May 29th of 2025. Mr. Patterson, you've been advised of your right to remain silent. Your attorney is Mr. White. May I place you under oath for the plea? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Nixon?
Yes, Your Honor, as for count one, it will be 12 months to serve 56 days, credit for time served 28 days, and that's from May 30th, 2025 until today. Balance prorated. No further contact with Portia Sterling. Stay away from State Farm Arena located at 1 State Farm Drive, Atlanta. As for count two, it will be 12 months from concurrent with count one, 12 weeks anger management, 40 hours of community service. I'm not sure if Ms. Sterling is on the line, but the state would ask that you would sound for when appropriate. And the state would ask also that the defense stipulate the venue, factual basis, and identification for the purpose of this plea.
Portia Sterling, if you're present, this is the time to unmute and start your video. Okay, no? Mr. White?
Your Honor, do stipulate for the purposes of plea, just accept the plea is negotiated. We would ask that the probation terminator go non-reporting upon completion of his requirements.
I'm open to non-reporting. Mr. Nixon, any objection?
No objection, Your Honor.
Okay. Mr. Patterson, have you consumed any medicine or alcohol recently?
No.
And have you understood what's going on in your case?
Yes.
Are you satisfied with your attorney?
Yes.
And if you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial. You will not be able to go back to court, confront your accuser, challenge evidence that could be presented before you, present your own defenses and arguments through counsel, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to criminal trespass and simple battery at the State Farm Arena from May 29th of this year?
Guilty.
Your sentence for the criminal trespass is 12 months to serve 56 days. Credit for time served 28 days. Balance probated. You will report to probation on Monday, June 30th before 3 p.m. While on probation, you have to have no contact with Portia Sterling, and you have to stay 200 yards away from the State Farm Arena at 1 State Farm Drive in Atlanta, Georgia. For count two, simple battery, your sentence is 12 months concurrent with count one. You are to enroll in a 12-week anger management program within 60 days of being on probation, and you have to complete 40 hours of community service at any nonprofit agency that is not a church and not a school. You're to do the community service at a minimum rate of 5 hours per month. Once you have completed all your conditions and your probation fees and costs are up to date, your probation will then be non-reporting. Thank you.
Thank you, Your Honor. Your Honor, I have an announcement on position 15. I don't think we've.
On Brenton Covert?
That's correct, Judge. We'd like to reset that to 7-3.
Do we have space on July 3rd, Ms. Champion?
Yes, we do.
Okay.
Thank you.
Mr. White, you finished with Patterson?
Yes.
Yes, we're concluded. Thank you.
So our remaining people are for Ms. McLeod, and they're interviewing with her now.
Ms. McLeod's
So, Mr. Mazarjudin and Mr. White, we have concluded with your cases.
Yes, Judge, I believe that's correct.
All right, I'm just going to wait for Ms. McLeod. So in the meantime, Ms. Greenhouse, do you need a break? Is this your required break time?
Oh, thank you, Judge Law. I'm fine. I'm actually fine. I can stay on until
Okay.
you need me.
You
But
let
thank
me
you.
know. I've got the standing orders for break times for reporters, so.
Well, I appreciate it. I really do, but I'm fine. Thank
Okay.
you.
Thank you. Okay, for the add-on calendar on positions 1, 2, 3, and 4, that was a plea for Mr. Edwards. For position 6, was a plea. Position 7 was a null pros. Let me correct. Add-on position 1 and 2 were pleas. 3 and 4 were null pros. Right, so I still don't know about positions 5, 8, and 9 on the add-on calendar. On the main SAP calendar, positions 1, 2, and 3 are waivers of arraignment and further notice for trial. Position 5, 6, excuse me, 4, 5, and 6, Bacchus is reset to July 8th. Position 7, Baker is, who represents Baker?
That's Ms. McLeod. She's speaking with him presently on the phone.
Okay, thank you. All right, that would be for 7 and 8. Position 9 was a plea. Position 10, Sherman Bell. What are we doing on Sherman Bell?
That is no conflict, Your Honor.
It's also a conflict?
Yes, Judge.
Position 10. All right. Ahmad Brantley.
Released.
Okay, thank you. Position 12, Carter, was a plea. Position 13 was a plea. 14 is reset to July 3rd. That's Collins. 15, Cowart, is reset to July 3rd. 16 and 17 is with Ms. McLeod. 18, Brenton Dennis.
Also a conflict.
Okay, that's position 18. Yesner Dutton is also conflict, position 19. Position 20, Anthony Ellison is a waiver of arraignment for the notice. 21, Farley, reset to July 3rd. 22, Ford is a plea. 23 is null Frost. 24, Frost is a waiver of arraignment and further notice for trial. 25, Gaskin. Matthew Gaskin.
Released.
Released, thank you. Ingram, position 26 and 27 are reset to July 8th, and 29, 28 is reset to July 8th. 29, Jenkins is conflict. 30, Laney was a plea. 31, Martin is a waiver arraignment for the notice. 32, McCants. 32 and
Release.
33, release, thank you. 34, Owens, waiver of arraignment and further notice. 35, Patterson is a plea. 36, Pitts is a waiver of arraignment and further notice. 37, Probst is a plea. 38, Chin is a waiver of arraignment and further notice for trial. 39, Rhodes is a plea. 40, Justin Seymour.
Released.
Thank you. 41, Smith is a waiver arraignment for the notice. 42, 43, 44, 45, 46 are waivers of arraignment and further notice for trial. 47 was a, 48 is a waiver of arraignment and further notice for trial. Bond remains the same. 49, White is a waiver of arraignment, further notice for trial. 50, Shankaria Wilkerson.
Your Honor, I believe she refused to come out. If we can reset her to July 8th, if there's space on that calendar.
I have July 8th. Do we have space on July 3rd, Miss Champion?
Yes, you can put it on July 3rd, Your Honor.
Okay, so Wilkerson reset to July 3rd. 51 Williams is a plea. 52 and was a Tier 3 Williams is a plea. 53 is null pros. 54 Williams Francois is a plea. 55 Anthony Wilson is a plea. 56 Brandon Wilson. Brandon Wilson. Are we still waiting on Brandon Wilson? Or have I addressed that? No, I have not addressed that.
We have not, that should be a negotiated plea, he wasn't brought.
Okay, and then 57 Youngblood is a waiver of arraignment and further notice. Okay. So for the SAP calendar with the PD's office, I'm waiting on position 56. And the other matters 7, 10, 16, 17, 18, 19, and 29 are with conflict. Ms. McLeod, are you ready to address any of these positions?
She's still interviewing the last person.
Okay.
But, Your Honor, I just had a question. The orders and plea forms, should we send that to Ms. Champion or Ms. Grace?
Please send them to Miss April Champion.
Okay, we'll do it. Thank you.
Okay, Mr. Bartel and Ms. Falk, I apologize, but we still have a full courtroom in courtroom 2, so until we either we have to wait until that's cleared out before we proceed with our competency, okay? So I think I've called the calendar. Mr. Mercer-Jardin, if you could check on position 56, Brandon Wilson. It's either going to be a plea or a reset, hopefully to July 3rd.
Your Honor, I believe they're bringing Mr. Wilson and we should be able to have that plea heard today.
Okay. Are you ready to move forward or do you need to speak with him?
I'm ready to move forward.
Okay, so we'll just be in a reset and just chime in when Mr. Wilson is in the courtroom, okay?
Will do. Thank you, Your Honor.
Thank you.
Ms. McLeod, are you ready?
I think Ms. McLeod may still be talking to someone.
No, we're down here in courtroom 2.
Oh, okay. If Ms. Grace, could you prompt Ms. McLeod to start video and unmute? There we go.
Yes.
Ms. McLeod?
Yes, Your Honor. Yes, Your Honor. I apologize. ACDC was speaking to me.
Oh, I see. I see. Okay. You let me know if you're ready.
We're gonna do.
I'm ready, and I apologize. I just had so many people on the calendar. I still had someone else at ACDC, but I would have to call them back.
This is the McLeod docket this morning, Ms. McLeod.
It appears that way, Your Honor.
All right, so let us begin. We have ACDC and courtroom 2. Courtroom 2, who should I begin with?
16 and 17, Ms. Daniel.
Okay.
Ms. McLeod, before we get started, do you have a position add-on number 9, Mr. Rabani? Is he one of your clients?
The name does not sound familiar. I can check.
Yes,
Bonnie.
Also, position 1, 2, and 3 on the regular calendar.
1, 2, and 3 is Mr. White's, and that was a waiver of arraignment and further notice for trial. Okay.
So Ms. Daniels is going to be a negotiated plea, Your Honor.
Thank you. This is State versus Patricia Daniel, 18 CR 5313G, accused of battery, family violence from August 17th, 2017. She's got a second case, which is a bench warrant for failure to appear, 25 FTA 1142 from June 2nd, 2023. Ms. Daniel has been advised of your right to remain silent, and your attorney is Ms. Maureen McLeod. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Paul, what's the recommendation?
Yes, Your Honor. The recommendation on the family violence battery is going to be 12 months served, 194 days, credit for time served 97 days. That's from August 18th to September 2nd, 2017, December 14th, 2018 to January 10th, 2019, December 9th, 2021 to January 15th, 2022, and then June 12th, 2025 until today. Balance probated, no further contact with Jerome Coggins. Stay away from 272 Hamilton E. Holmes Drive in Atlanta, 40 hours of community service, and a family violence intervention program. Position 17, the state will null pros upon the acceptance of the plea to position 16. We would like to sound for Mr. Jerome Coggins at this time, and that's all for the state. Oh, we do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea.
We do so stipulate, but my client did ask me to let you know that after this incident allegedly happened, they actually got married. She also tells me that Mr. Coggins is currently incarcerated, and this incident is from 2017, I believe. It's really quite old.
Any objection to no further violent contact?
No
That was what
objection.
I was going to ask.
Right. No,
But-
no objection to no further violent contact. I will say we have not, if he's incarcerated, that explains why. We have not been able to reach Mr. Coggins, and I'm assuming by the time he gets out of wherever he's incarcerated from, she would have completed the probation anyway. So we don't object.
Any objection to amending FVIP to anger management?
We do object to that.
All right, thought I'd throw that out. Okay. Ms. McLeod, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
Ms. Daniel, have you consumed any medicine or alcohol recently?
No, Your Honor.
Have you understood what's going on in your case?
Yes, Your Honor.
And are you satisfied with your attorney?
Yes, Your Honor.
If you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not be able to go back to court to confront your accuser. You will not be able to have your attorney help you to challenge the evidence brought against you, present your legal defenses and arguments, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of battery, family violence?
Guilty.
Your sentence is 12 months to serve 194 days, credit for time served 97 days. You will report to probation on Monday, June 30th at before 3 p.m. While you're on probation, you have to have no violent contact with Jerome Coggins. Is the Hamilton E. Holmes address still relevant?
No, Your Honor, we moved. We have our own, we moved after we got married.
Okay, I'm going to take out the stay away provision. We don't need that. Miss Daniel, you're going to have to do 40 hours of community service. And you're to do the community service at any nonprofit agency that's not a church or school. You should do it at a minimum rate of 5 hours per month. The state, because of the nature of the charge, you'll also be required to do a domestic violence program. And this is a series of 26 classes that you would need to enroll and complete all classes at your expense. I'm going to waive your probation fees for while you're on probation, but I want you to use the money towards taking those classes. Okay? So you will have to enroll in those classes within 90 days of being released.
Yes, Your Honor.
All right, so instead of paying probation, I'd rather you use that towards your classes.
Yes, Your Honor.
Okay. That's it. Thank you.
Thank you, Your Honor.
So, and the bench warrant is null pros. And then that moves us on to, that was positions 16 and 17. Where do we go to next? Courtroom 2?
Number 20. Jenkins.
Your Honor, can I do Ms. Natasha McClendon so I can go down to 4 Northeast to check on Ms. Dutton?
I'm sorry, repeat that again?
She wants to do Miss McClendon, Your Honor, because I have another client that she needs to get.
Okay, Courtroom 2, could you hold please and let me get to Miss McClendon? And that's position number, is that on the add-on?
Yes, Your Honor, it is.
Okay, this is Natasha McClendon, case 25 CR 3200J. Ms. McClendon, you've been advised of your rights and your attorney is Ms. McLeod. You are under case number 3200J. You've got 4 misdemeanor charges stemming from a June 5th, 2025 incident, accused of simple battery, family violence, willful obstruction of an officer, and one more count of simple battery, family violence, and simple battery against a police officer. You've been okay, and this is going to be a plea, Ms. McClendon?
It's a non-negotiated plea, Your Honor.
Okay, and so Ms. McClendon, for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Okay, thank you. Mr. Nixon, with regards to Ms. McClendon, what's the recommendation for the 4 charges?
Yes, Your Honor. As for count one, it'll be 12 months to serve 60 days, credit for time served 19 days. That's from June 6, 2025 until today. Balance probated, FBIP, 40 hours of community service. No further contact with Tamika McFadden. Stay away from 2950 Springdale Road, Southwest in Atlanta. No firearms. Reference to count two, it would be 12 months to run concurrent with count one and a $300 fine. As for count three, as for count three and four, they'll both merge with count one. And Your Honor, if I may go over a brief basis of the factual basis in this case. This occurred on
Just,
June.
Mr. Nixon, just one small correction. It's now 21 days because the 19 days was from Tuesday.
Correct.
Remember, she was on Tuesday.
You are correct, yes. So yes, Your Honor. So again, on June 5th, 2025, Officer Ash was dispatched to 2950 Springdale location there. As previously mentioned, when he arrived at the location, officer heard screaming from the apartment. The officer then knocked at the door and a child opened it. And the officer then saw two females fighting each other on the ground shortly after. Both females were separated. At one point, the victim was on top of the defendant, and then the defendant was on top of the victim. Ms. McFadden stated that there were not related or in a relationship. That's the victim, Tamika McFadden here. Ms. McFadden stated that they were not in a relationship and they were just two roommates for around 4 months. And McFadden stated that she was sleeping at the location and then Ms. McClendon woke her up. Ms. McFadden stated that she and the defendant, Ms. McClendon, were having a verbal altercation regarding the defendant's lost EBT card. And then an altercation ensued, and while fighting, Ms. McFadden, the victim, stated that the defendant bit her left breast and was pulling her hair. The defendant was on top of the victim and pulled her hair. The defendant stated she was intoxicated while speaking with the officer. The officer noticed that there was clumps of hair on the ground from the defendant and the victim here. Ms. McClendon was determined to be the primary aggressor, and when being arrested, kicked the officer as he was trying to place her into the patrol vehicle. I've noted relevant criminal history. Actually, it's a 2016 battery, family violence, ag assault, ag battery, cruelty to children. That was from 2016. She was on probation for 9 years. Different victims, however. But even in the 2023 battery family violence, I believe she pled guilty to that. And that was for biting another victim and was arrested on a 2024 ag assault, 2 counts of cruelty to children, giving false name, date of birth, battery, cruelty to children in the third, another battery family violence. Per the history of violent arrest, the conviction, as well as the facts in this case, is why the state is asking for this particular recommendation. And as such, the state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
We do so stipulate.
Ms. McClendon, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to the simple battery and the willful obstruction of an officer, you would have to give up your constitutional right to a trial. You will not be able to go back to court to confront you, to face your accuser, challenge the evidence brought against you, and have the state would not have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to simple battery, family violence, and willful obstruction of an officer?
Guilty, ma'am.
On the simple battery, it's going to be 12 months to serve 60 days, credit for time served 21 days, balance probated.
Your Honor, this was a non-negotiated plea. It was on the issue of the time.
Oh, I'm so sorry. Was it non-negotiated? I didn't know that. Okay.
Yes,
So,
yes, Your Honor. The court may not have
okay,
heard
yeah.
when I said that was non-negotiated.
Do beg your pardon. Okay. And okay, I should have caught that when Mr. Nixon was allocating the alleged facts. Sorry about that. So I'm going to hold off on this plea. I'm not going to accept it at the present time. Go ahead, Ms. McLeod.
Yes, Your Honor. This whole situation I recall distinctly when she was arrested because I represented her at first appearance. And what she told me at the time was that she had this EBT card. It was really important. And then this woman had taken her EBT card from her. When she asked her for it, then the alleged victim was the one that started to fight, and that's how they got to fighting. And my client was the one who actually called the police to the scene. And my client is willing to take responsibility for her part in all of this. But her issue, why the police non-negotiated, Your Honor, is the time, the amount of time. My client really wants to get out of jail now. And they want her to spend it on, when we came the first time, it was another 11 days. Now it's going to be another 9 days. And she really wants to get out because she has, things that are going to go south for her, including her accommodation and so on, if she doesn't get out of jail quickly. But she is okay with all the other recommendations being made for the state. She's given me good contact information for, probation and everything else, Your Honor. It was just the issue of the time.
Where does she plan to live?
I have an address for her, Your Honor. She does not live at that place, and they were not roommates, actually.
Okay. I'll accept the defense recommendation to do 12 months to serve 42 days. Credit for time served 21 days, and all other remaining conditions remain the same. Is that acceptable to your client?
Yes, Your Honor, because that was the biggest issue for her, was getting out of jail. But she's okay with everything else the state is asking.
Right. So, Ms. McClendon, with this modification to the sentence based on this non-negotiated plea, are you willing to move forward with this plea?
Yes, ma'am.
All right. And I'll just pick up from where I left off. And so you understand that if you decide to enter this guilty plea, you would have to give up your right to a trial, to confront your accuser, challenge the evidence, and the state won't have to prove the charges beyond a reasonable doubt. Do you waive these rights?
Yes, ma'am.
How do you plead to simple battery, family violence, and willful obstruction of an officer?
Guilty, ma'am.
Right. Your sentence for simple battery, family violence is 12 months to serve 42 days. Credit for time served 21 days, balance probated. Once you're released, you report to Fulton Probation on Monday, June 30th before 3 p.m. While on probation, you will enroll in a domestic violence intervention program and complete all 26 classes at your expense. You must enroll within 60 days of being released. You have to do 40 hours of community service at any nonprofit agency, and you have to do the 40 hours at a minimum rate of 5 hours per month. No contact with Tamika McFadden. Stay away from 2950 Springdale Road in Northwest Georgia, and you're not allowed to consume any illegal drugs, no alcohol, and not possess and own any firearms. Count 3 and 4 will merge with count 1. Thank you.
Thank you.
Position number 22, Jenkins.
This is State versus Akpan Jenkins, accused of 2 counts of abandonment of dependent child, case 25 CR 3317C. He's been advised of his rights, and his attorney is Ms. McLeod. Ms. McLeod, this is 2 counts of abandonment with a purge of 387. How would your client like to proceed?
Your Honor, it is going to be a negotiated plea.
Okay, thank you. Please raise your right hand, Mr. Jenkins. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes, no?
Yes.
Thank you. Is that the terms of the plea, Mr. Nixon? Probation and pay off the purge?
Yes, and we agreed to terminate upon payment of the purge.
Okay, thank you. Ms. McLeod, you stipulate to the factual basis, venue, and ID?
We do so stipulate, Your Honor.
All right. Mr. Jenkins, are you have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes.
If you decide to plead guilty, you would have to give up your right to a trial. You'll not be able to go back to a courtroom to challenge these charges, challenge the evidence, and the state won't have to prove them beyond a reasonable doubt. Are you prepared to give up these rights?
I am.
How do you plead to 2 counts of abandonment of a dependent child?
Guilty.
Count 1 is credit 12 months to serve 226 days, credit for time served 113 days. You'll be on probation, and you report to probation on Monday, June 30th, before 3 p.m. You'll be on probation to pay off the $387 purge amount. I will waive your probation fees for the first 3 months, and if the $387 is paid off, then within the 3 months, your case is probation will terminate. Otherwise, you will continue on probation and start paying probation fees from month number 4, in addition to your purge amount. And the probation will terminate when the purge amount is paid and all probation fees are up to date. Count 2 will be concurrent with count 1. Thank you.
Your Honor, he wanted to know where exactly he should pay the purge amount to.
He pays it to probation, who will then direct it to the Office of Child Support Services, if that's
Thank you,
who's
Your Honor.
monitoring the child support.
Thank you.
Thank you.
Number 10, Mr. Bell.
This is State versus Yesnia Dutton, accused of simple battery against an officer, willful obstruction of an officer, and criminal trespass. The criminal trespass.
Your Honor, I believe she said Mr. Bell.
The position
Oh,
number.
I'm sorry, I'm sorry, I went to Mr. Dutton. Sorry about that. I think it's because of the changes in the position of this. Okay, sorry about that.
We
Okay.
are going to get Miss Dutton at a later point, Your Honor, at ACDC. I think that's where she is.
Okay, and you know there are 2 cases in Ms. Dutton's.
That is correct, Your Honor.
Okay. I beg your pardon. This is Sherman Bell at courtroom 2, case number 25 CR 003313D. Mr. Sherman Bell is accused of battery, family violence, and 2 counts of simple battery, family violence from March 28, 2025. Mr. Bell, you've been advised of your rights. Your attorney is Ms. McLeod. And is this going to be a plea?
Yes, Your Honor, it's a negotiated plea.
Thank you. Mr. Bell, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes or no?
Yes.
Thank you. Ms. Falk?
Yes, Your Honor. State's recommendation on this is 12 months served, 30 days, credit for time served 15 days from June 12th, 2025 till today. Balance probated, 40 hours of community service, FVIP, no further violent contact with Aaliyah Dillingham. Counts 2 and counts 3 will merge with count 1. We did speak with Ms. Dillingham on this case. She stated that she is okay with the plea recommendation if the defendant accepts.
I'm on the call.
I understand that, Ms. Dillingham. I'll call for you in a moment. Our victim advocate did speak with Ms. Dillingham. She did state she is okay with the plea recommendation if the defendant accepts it. She did also state that they share a child and another child is on the way, which is why the state has asked for no further violent contact instead of no further contact. I will state it appears, let me just make sure, that this technically would release Mr. Bell, but I'm not sure if he's actually being held on probation violations, which would keep him in custody, even though this would conclude this case, which is correct. He's on a 22 SC 184927. So this will conclude his misdemeanor case, but his felony case he will still have to address. We do ask the
that was
defense
his
to
understanding that there was a probation hold. We spoke about that.
And we do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. That's all for the state. We would like to sound for the victim in the case.
All right. Aaliyah Dillingham, if you'll unmute. Or Ms. Grace, if you can prompt her to unmute. All All right, Ms. Dillingham, we can only see, well, now we can't see you. And now you need to unmute.
Okay, you're unmuted.
All right. And then you put your hand down and make sure your phone is in front of your face, not above your forehead or anything. All right. Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
What would you like to tell us?
It was a misunderstanding. I was going through postpartum.
No. You're not talking to the side of the room. You're talking to the phone, and make sure your entire face is on the screen.
That's what I'm sorry.
Yes, I was saying that it was a misunderstanding. I was going through postpartum at the time of the incident. So it wasn't all his fault. It was both our fault.
Hold on.
Anything else?
No, ma'am, that's all.
Listen,
Thank you. Ms. McLeod, anything to add?
do you guys have her?
No, Your Honor.
Okay. Do you stipulate to the factual basis venue and ID, Ms. McLeod?
Yes, Your Honor.
Thank you. All right, Mr. Bell, have you consumed any medicine or alcohol recently?
Yeah. The medication I get from
Okay, so when you give them, just call back.
not no drug medication though.
Okay.
Did you consume any prescription medication recently?
You talking about for my health?
Yes.
Yeah.
And are you still able to understand what's going on in your case?
Yes.
Are you satisfied with your attorney?
Yeah.
Put your hand down.
Yes. I do need to say something though. I know, man.
Mr. Bell, I think it's probably a good idea for you not to say anything, just to answer the judge's questions, okay?
If you decide to plead guilty to battery family violence, this you would have to give up your right to a trial in front of a judge or a jury. You will not be able to go back to a courtroom, have the assistance of counsel to challenge the evidence brought against you, confront your accuser, be able to present your legal arguments and defenses, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yeah.
Sorry?
Yes.
I accept your plea and sentence you on the battery family violence charge to 12 months to serve 30 days, credit for time served 15 days.
Yes.
Once you have resolved all your holds, you will report to probation within 48 hours of being released. On probation, you will complete a domestic violence intervention program, and you will enroll in that program within 30 days of being released.
Yes.
This is a series of 26 classes, and you will attend and complete every class without missing or skipping them and pay for them out of your own pocket. You have to complete 40 hours of community service at any nonprofit agency, and this must be done at a minimum rate of 5 hours per month. You are to have no further violent contact with Alea Dillingham. Within 60 days of being released, you will file a legitimation case, and you will legitimate the child or children that you have with Miss Dillingham. You are not to consume any illegal drugs. You're not to consume any alcoholic beverages, and you'll be subject to random screens by probation. You report to probation every month. And if you get arrested again while you're on probation, this will be grounds to revoke your probation and have you serve out the rest of the time in jail. Counts 2 and 3 will be null pros. I'm sorry, not null pros. They will merge with count 1.
Yes. Email.
All right. That concludes Mr. Bell's case. Thank you.
Thank you, Your Honor.
Next case.
Mr. Baker, I'm not sure of the position number.
Okay. That would be positions 7 and 8 on the updated calendar. This is Lamarcus Xavier Baker. On first case is 23 CR 3996D, accused of battery and 1 count of riot from June 22nd, 2023. His second case is a bench warrant from August 19th, 2024, 25 FTA 1113. Mr. Baker, you've been advised of your rights, and your attorney is going to be Ms. McLeod.
Yes, Your Honor. And this is going to be a negotiated plea as well.
Thank you. Mr. Baker, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
Thank you. Ms. Maffolk?
Yes, Your Honor. So the state's recommendation on the battery is 12 months served, 118 days, credit for time served 68 days. From June 22nd to July 29th of 2023, April 26th to May 4th of 2024, and June 6th of 2025 to today. Balance probated, 40 hours of community service, 12 weeks of anger management. Count 2, the riot, will merge with count 1. I will state that the defendant does have an open probation violation and a felony theft by receiving stolen property with a surety bond. So this may not resolve, well, this will likely not resolve his pending cases that are holding him in jail. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state. And on position 8, we will enter a null pros. I apologize, Ms. McLeod. I did not mean to interrupt you.
No, no worries. We do so stipulate.
Thank you. Mr. Baker, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Ma'am.
I'm sorry?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
I'm sorry?
Say yes, ma'am.
Okay. If you decide to plead guilty to 1 count of battery, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be able to go back to court to face your accuser, challenge the evidence brought against you, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yeah, ma'am.
How do you plead to 1 count of battery?
Guilty.
Your sentence is 12 months to serve 118 days. Credit for time served 68 days. Once you have resolved any and all holes that you presently have, you will report to Fulton County Probation within 48 hours of being released. While on probation, you're to do 40 hours of community service at any nonprofit agency at a minimum rate of 5 hours per month. You're to complete 12 weeks of anger management, which you must enroll within 60 days of being on probation, and complete all classes without missing or skipping any of the classes. On the riot charge, that will merge with count 1. Thank you. And for the
Thank you, Your Honor. And I do have to speak to my other client at ACDC, Your Honor, but I anticipate it will also be a plea.
Okay. So for Mr. Baker, the bench warrant is null pros. And ACDC, Ms. McLeod is going to speak. I think, Ms. McLeod, you have positions 18 and 19. Are
Which
they?
ones are those, Your Honor? The names?
Yeah, I think there were 2 of them. Just give me a moment. Lots of pages over here. Okay, there we go.
Yes, I need to talk to her.
There we go. Brenton Dennis and Yesnia Dutton.
Yesnia Dutton is my client, Your Honor.
Okay. Brenton Dennis, courtroom 2. Do we have Brenton Dennis in the courtroom? Mr. Judin?
I'm sorry, Judge.
Position 18, Brenton Dennis. I think you announced that a conflict is required.
Yes, that's what I was advised, that he is a conflict client.
Okay, any chance he'll be brought today?
He refused. They went up for him earlier. He refused.
Okay. Ms. McLeod, I'm going to appoint you to Brenton Dennis, case number 25 CR 003126E. And his case is going to be reset to July 3rd. Okay, and so she's speaking to ACDC. And courtroom 2, you have Mr. Wilson.
Yes,
Yes.
Judge, 56.
Okay. This is State versus Brandon Moore Wilson, 25 CR 3118G. Mr. Wilson's accused of a PI charge and giving false information to an officer from June 1st, 2025. Mr. Wilson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, Mr. Maser Jadin will be your counsel. What are we doing today, Mr. Maser Jadin?
Mr. Wilson does intend to plead guilty and accept the state's offer.
Okay. And Mr. Wilson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Ms. Falk, what's the recommendation?
Yes, Your Honor. State's recommendation is 12 months, serve 150 days, credit for time served 25 days. That will be from June 2nd, 2025 until today. Balance probated, SDET, no further contact with Caleb Cesare. Stay away from the Quick Trip at 761 Sidney Marcus Boulevard in Atlanta, 40 hours of community service. Count 2, the giving false information to a law enforcement officer, 12 months concurrent with count 1 and a $300 fine. We do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea. We will state that this should release him in the next 24 hours. There are no other pending cases. That's all for the state. And we would like to sound for Mr. Cesare.
Yes, that's what they use.
Caleb Cesar. If you're on Zoom, this is the time to unmute and start your video. All right. Mr. Jadin, what would your client like to do?
Thank you, Your Honor. Defense so stipulates, and Mr. Wilson does intend to plead guilty.
He understands that he has 50 more days to serve at the Fulton County Jail. That's 50 whole days, not half a day.
I thought you were saying, I'm seeing what he's saying.
That's once you finish.
I thought, no, she said I was being released within 24 hours, right?
Mr. Wilson is confused that Ms. Falk stated that he would be released within 24 hours. I believe that's once he's finished. He's going to have to serve 50 more days under the.
I apologize, Mr. Masajidin. You are absolutely right. I misspoke. He will have the remaining time to serve and then will be released.
50 more days.
I mean, 15 more days or 50?
5-0. Can you understand? You okay with that?
You can mute the screen, Mr. Jadin, if you need to speak with him.
Well, I appreciate it, Judge. Mr. Wilson understands he's ready to proceed with the plea agreement.
That's why I wanted to repeat that. I did hear Ms. Falk, but I understand it's been a long morning. Some of us trip up. So, Mr. Wilson, if you decide to plead guilty to these charges, the sentence would be 150 days. You'll be given credit for 50 days. That leaves a balance of 100 days. The sheriff reduces that to 2 for 1. So you have 50 whole more days to serve at the Fulton County Jail. After that, you'll be placed on probation, and then you'll need to do certain things while on probation, including community service and an evaluation and treatment. Do you understand?
Yes.
Is this what you want to do?
Yes.
Okay. Mr. Wilson and Mr. Masarjadin, we are stipulating, right?
Yes, Judge.
Mr. Wilson, have you consumed any medicine or alcohol recently?
No.
Have you understood now what's going on in your case?
Yes.
And do you understand the plea offer?
Yes.
Are you satisfied with your attorney?
Yes.
Are you entering this plea freely, willingly, and voluntarily?
Yes.
You understand that if you enter this plea, you give up your right to a trial in front of a judge or a jury. You will not be able to go back to court, face your accusers, challenge the evidence brought against you. I'm sorry, Miss Grace, can you switch off Gwendolyn Dean? I don't need to see her grocery shopping. Switch that video off. Thank you. As I was saying, you will not be able to confront your accuser, challenge the evidence brought against you, present your own legal arguments and defenses in a court of law, and the prosecutor won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to count 1, the PI charge, and
Yes.
count 2, giving false information to an officer?
Guilty.
Your sentence for count 1 is going to be 12 months to serve 150 days, credit for time served 25 days. Once you've completed the 50 whole days, you'll be placed on probation. You will report to probation within 48 hours of being released. While on probation, you are to have no contact with Caleb Caesar. You are to stay away from the Quick Trip gas station at 761 Sidney Marcus Boulevard in Atlanta, Georgia. This means 200 yards away, so the length of 2 football fields, and you cannot be at the parking lot or on the sidewalk or even in the store. You're to complete 40 hours of community service at any nonprofit agency, and you're to do the community service at a minimum rate of 10 hours per month. Within 60 days of being released, you must enroll in an SD evaluation and submit yourself to all treatment that's required. For count 2, it will be 12 months probation concurrent with count 1 with a $300 fine, and he has to pay the fine at a minimum rate of $50 per month. If he gets arrested again, if he fails to report to probation or fails to comply with the conditions, his probation will be revoked and he will complete the rest of the time in jail. Any questions? All right, thank you. Ms. Grace, we can mute Gwendolyn Dean, please. All right, AC/DC, we are addressing position number 19, I believe.
Yes, Your Honor, Ms. Dutton.
Okay. This is Yesenia Dutton, accused of simple battery against an officer, willful obstruction of an officer, and criminal trespass. Case number 25CR1871J. Ms. Dutton, you've been advised you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. McLeod. Ms. McLeod, she also has a second case, 25CR001042J, for criminal trespass and obstruction of a law enforcement officer. And this will, I guess, gather will be a global offer. Ms. Falk?
Yes, Your Honor. State's recommendation on the simple battery against a police officer is 12 months, serve 160 days, credit for time served 80 days from April 8th, 2025 until today. Balance probated 40 hours of community service, MHET, and no firearms. On the willful obstruction, 12 months, serve 160 days, credit for time served 80 days, concurrent with count 1, balance probated, and a $300 fine. On the criminal trespass, 12 months, serve 160 days, credit for time served 80 days, concurrent with count 1, balance suspended, and stay away from Publix at 2900 Peachtree Road Northwest in Atlanta. On the add-on case, which is a criminal trespass, state's recommendation is 12 months, serve 32 days, and balance probated. That is from February 27th to March 14th of 2025. And on the obstruction of a law enforcement officer, 12 months, serve 32 days, credit for time served from February 27th to March 14th of 2025, which should be 16 days. Balance probated and a $300 fine. We do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. That's all for the state.
What's the stay? I'm sorry, Ms. McLeod. I would just want to clarify. What's the stay away for the criminal trespass on the add-on case?
Let me just take a look at that briefly, Your Honor, and I can get you that information in a moment.
Okay. I'm sorry, Ms. McLeod, you were saying?
Yes, Your Honor, I was about to stipulate to venue ID for the purposes of the plea, Your Honor.
Okay. And factual basis?
and factual basis. Yes, Your Honor. And I also wanted to say that my client has been locked up for quite some time. So she's not working, she's not employed. So it may be a little rough on her trying to pay that $600 over time. So I would ask the court to consider waiving any probation fees for at least the first 6 months for her. She has to take that MHET also, which she is quite willing to do, Your Honor. I've spoken with her.
All right.
So whatever concessions can be made for her, I would ask.
Let me find out what was that second location.
Yes, Your Honor. First, Ms. McLeod, would your client be agreeable for me striking count 2 and modifying that to time served, which would then eliminate the fine on the
Yes.
first case?
We would definitely appreciate that because, you know, we talked about that and that would be a real hardship for her. In fact, we thought about going non-negotiated just because of the fines, you know.
And Your Honor, the second location is the McDonald's at 2929 Peachtree Road in Atlanta.
2929, it's close to the Publix, same location. Okay.
It is. It's within the same block. Yes.
Okay. Yes, Ms. McLeod, with regards to count 2 in the first case ending in 1871J, there'll be a modification to 12 months to serve, 160 days, credit for time served, 80 days, balance suspended. And then for the add-on case, there'll be a stay away from the McDonald's at 2929 Peachtree Road. Is your client willing to accept these terms?
Yes, Your Honor, she is.
Right. Ms. Dutton, please raise your right hand.
I can't.
All right. Understood. Understood. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Ms. Dutton?
Yes, Your Honor.
All right. Ms. Dutton, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in both your cases?
I just did. Yes, ma'am.
And do you have any questions to ask of your attorney?
What was the amount for the fines?
It's now 300. If your first case was modified to strike the fine, so the fine now is 300.
Okay, and
Instead
does
of
that mean
600, as I had discussed with you earlier, okay?
Oh, okay. Okay, just like we discussed.
Yes.
All right, thank you. That's
And
it.
the probation fees are going to be waived for 4 months.
Okay, thank you.
Do you have any other questions to ask of your attorney?
No, that's it.
Okay. And are you satisfied with your attorney services?
Yes, I am.
If you decide to plead guilty in both these cases, you would have to give up your right to a trial in front of a judge or a jury. You will not go back to a courtroom to face your accusers, challenge the evidence brought against you. Your attorney won't be able to assist you to present your legal arguments and defenses, and the state won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
I mean, will that be added information that I will not be able to, like, possibly fight against?
Correct. You will not be able to challenge these charges in a court of law for the rest of your life.
I don't know about that. It's a lot because there's so much that happens out there that I don't have control over.
Well, if you don't want to plead guilty, then you definitely have a right to go to trial.
Will that just be to this already written statement that I can just go ahead and plead guilty to that?
Ms. Dutton, if you decide to plead guilty to these charges, you will never be able to challenge these charges in a court of law for the rest of your life. But if you want to assert any challenges, I highly recommend that you preserve your rights and go to trial.
I'll take the plea.
I'm sorry?
I'm sorry for your time. I'll take the plea.
You're not wasting my time. I don't want you to plead guilty just because you want to get out of jail. Because once you take this plea Any challenges you have will be gone, and you will be required to stay away from that entire block at 2929 Peachtree Road and 2900 Peachtree Road. That entire area, you won't be allowed anywhere near there. So if that's your favorite Publix and if that's your favorite McDonald's, you're not going to be going there for at least 1 year.
Okay,
What would you like to do?
I'll take the plea.
Okay. How do you plead to simple battery against an officer and willful obstruction of an officer and criminal trespass from April 7th, 2025?
Guilty.
Oh, you haven't answered my question yet. Do you waive your constitutional rights to challenge these charges?
That waiver, yes.
I'm sorry?
Yes.
Okay. So you do plead guilty to the 3 charges from the first case. On the second case, how do you plead to criminal trespass and obstruction of a law enforcement officer from February of 2025?
That one I plead. Did I not plead that one already?
You just pled to the Publix case from April 7th, 2025.
And we went over the one with the other officer, but I pled guilty, right?
With regards to the Publix incident in April of 2025. Now I'm asking you about the criminal trespass and the obstruction charge.
Well, they
at
kind
the
of,
Mc-
to me, it just seems like they kind of come hand in hand, like you just can't separate them for some reason, that I can't fight it. I was there spending money personally for, for me to order a sandwich, and she upcharged it, and I wasn't able to afford that. So, I mean, to sit into jail, I really can't handle jail much longer.
Ms. McLeod, I'm not accepting this plea offer. This young lady is entering a plea just to get out of jail, but she has a bona fide dispute with the facts. So I am disregarding the stipulation. Would you like to file a waiver arraignment, or shall I arraign the case?
One is already filed, Your Honor.
Okay. Both cases are going to be have been arraigned, and they are going to be further notice to trial. Thank you, Ms. Dutton.
Your Honor, could we address the issue of a bond for Ms. Dutton, a signature bond? She's been in jail a long time.
Certainly. Let me get to that case. Courtroom 2, I think we've concluded with all cases there, so we're good. Did you need anything, Mr. Misarjidin?
No, Your Honor, nothing from me. Thank you, if I'm excused.
All right. I didn't know. Yes, you are, sir. I just didn't know if they wanted to prepare it for the next proceeding. Mr. White, you're excused as well. And anyone else who's not involved in the competency calendar, you are also excused. On Miss Dutton, for the Publix case, I'm just going to refer to it that way. That makes it easier. She's got a $1,500 surety bond. And with regards to the case involving the McDonald's incident,
Your Honor, reset that bond to a $1,000
signature bond through the jail.
signature bond through the jail.
Well, originally the bond was $10 cash,
Correct.
but now it's $1,000 signature bond through the jail.
Yes, Your Honor. But it's the other bond. She doesn't have anyone to help her pay anything. And that's why she's still in jail.
It's not a question of help, Miss McLeod. It's a question of reoffending or being able to report to court. So
I
let's stick to
understand,
the
Your Honor.
jail
She has
facts.
some MH issues and they acknowledged, and I think some of it is evident, Your Honor, but she's been in jail a very long time.
And it appears at some point she was a loan out, Your Honor. I'm hoping you understand what I mean.
I
by
do.
that.
I do. Okay. Ms. Falk, I'm assuming Ms. McLeod's asking me for a signature bond through the jail.
That is correct, Your Honor.
Okay.
And Your Honor, the only problem with that is based on her history, she'd have to be a signature bond through pretrial services to be in compliance with SB 63 due to the failures to appear and the criminal trespass. She has both. And so it's kind of for her, it's not just one reason that she's SB 63, it's two.
Well, even if it is through pretrial, just something to get her. She's been in a long time. And I think while she was in jail, she had a visit to either Anchor or one of those other places.
And again, Your Honor, state doesn't object to a signature bond through pretrial services with monitoring. This is her 10th cycle, so she doesn't have a lengthy history, but it is mainly criminal trespass, which makes sense given the situation.
Yes. And, you know, she's been in jail a long time, and we've spoken many times.
On the simple battery against an officer, that's going to be $250, signature bond through pretrial level 1. She can do telephonic reporting. Position number 2 is going to be a $250 signature bond through pretrial, and criminal trespass is going to be $500 signature bond through pretrial. And I'm going to keep the same bond on the older case. Miss Dutton will have to report to pretrial either in person or via telephone once a month. But more importantly, this is the most important part. She cannot afford to get arrested again while she is out on bond. Because if she gets arrested again while out on bond, that signature bond will be revoked. Hope she understands that. She's required to stay away from the Publix grocery store at 2929 Peachtree Road and stay away from the McDonald's at 2900 Peachtree Road. And if she returns to any of those locations, if she interacts with any of the staff at those two locations, she'll be in violation of her bond order. No illegal drugs, no alcohol, and no weapons. Ms. McLeod, please stress to her that if she has any more entanglements with the law or with the police, she risks losing her signature bond.
I understand, Your Honor. And Ms. Dutton, as soon as you get out, please give me a call, okay? I know you have my number because we have spoken several times.
Your Honor, I hate to do this, and if you say no, I completely understand. Can I just speak to Ms. McLeod just really briefly in a breakout?
Sure. Mr. Bartel, we good?
Yes, Your Honor, everything's fine.
Okay. Miss Grace, if you will place Miss McLeod and Miss Falk to a breakout room, please.
And ACDC, if you could just hold on to Ms. Dutton for just 2 more minutes. Thank you.
All right, we'll be in a brief recess for 2 minutes or thereafter. Miss Hardy, if you are still on Zoom, you're free to go.
Judge Law,
Yes.
tried to make it quick. After listening to what Miss Dutton had to say, the state went back and looked at the warrant on the criminal trespass, and Miss Dutton is accurate about the fact that they were trying to criminally trespass her. She had not actually been criminally trespassed at the time of the incident. And additionally, it was the basis for them taking her into arrest was because she refused to give her ID, not because she refused to leave or do something else that would constitute criminal trespass. So by that rationale, she is correct. I spoke to Ms. McLeod, explained the situation after looking at the warrant. The state is agreeable to null processing the second case and just moving forward on the first. If Your Honor is agreeable to that, it doesn't appear that Ms. Dutton had any objection to pleading to the first case.
All right. So I'll accept a null pros on the McDonald's case, and we'll just proceed on the Publix case. And she's required to, and you've got the signature bond on the Publix case, and she's required to stay away from the Publix at 20.
I believe they're null processing the Publix case anyway.
Oh, I'm a little
No. It's the McDonald's case we're null processing. We're
the McDonald's case. I'm sorry.
Right.
I'm so
We're
confused.
proceeding on the Publix case, and Ms. McLeod and I discussed whether her client would like to take a plea on the Publix case, since that is the case she had no problem taking a plea on if we do null process the McDonald's case.
And since I think we'd agreed there would not be a fine on that case, correct? On
That
the
is
Publix
correct.
case.
So she wouldn't have any
there will be
fines to
no
pay.
fine at all.
All right. So with regards, Ms. Greenhouse, sorry, let's start again. No, I'm going to be brief. 25 CR 001042, as I affectionately refer to it as the McDonald's case, that is dismissed. And so that is the issues that Ms. Dutton had are now no longer in existence. Ms. Dutton has already taken a plea on the 25 CR 001871J per the record. So I am going to reinstate that plea and require her to stay away from the Publix grocery store at 2900 Peachtree Road. She will, as soon as she is released, she will report to probation to do 40 hours of community service, enroll in an MH evaluation, and submit herself to any treatment, and not possess any firearms. With regards to the willful obstruction, that's going to be time served, serve 160 days, credit for time served 80 days. And with regards to count 3, 12 months serve 160 days, credit for time served 80 days, stay away from the Publix. McDonald's is no longer an issue. That concludes Ms. Dutton's cases.
Thank you, Your Honor.
Oh, and I'll still waive the probation fees for 4 months.
Thank you, Your Honor. So, Ms. Dutton, you should be getting out of the next 24 hours and you do not have any fines, okay? You just have to stay away from the Publix. But the McDonald's, you can go there. Just don't get into anything with them there. If you want a Big Mac, that's okay.
I will say, just out of an abundance of caution, because they were trying to criminally trespass her, I'd stay
You
away
probably
from
shouldn't go
McDonald's
there.
too.
If you want a Big Mac, I suggest going to another McDonald's.
They only have 1 billion of them out there. Okay, thank you.
Thank you, Your Honor.
Thank
I
you,
believe
Deputy
that
Milton.
finally concludes my business before the court today.
I know.
May I be excused?
I'm gonna call you in a few minutes for misdemeanor.
Oh, you want me to do okay.
Thank you.
You all just keep me so busy.
Have a good day. Thank you, Your Honor.
Thank you.
Bye-bye.
I think we only have our competency calendar left, and Ms. McLeod.
I have one on there, Mr. Rooker. I totally forgot, Mr. Rooker. So much is going on.
He's the only conflict case on.
Not a problem. We have some folks here who want to address a competency matter. So first of all, let me make sure that only the individuals. So JCS, I think you are free to go. Mr. Tom White, Miss Grace, you can remove them from Zoom because they don't need to be. I'm sure they can have lunch now. ASG Justin Nixon, does he want to stay?
He doesn't need to if he is free to go if he wishes to leave.
Okay. Okay. Who is William Davis? William Davis, Andrew Beatty, Gwendolyn Dean, Latoya, and Nasha B.
Nasha B is on the Mr. Arquart case, and Mr. Beatty is on Mrs. Beatty's case on the 11 a.m. calendar.
They need to unmute and start their videos.
Excuse me, Judge Law, did you want me to stay for any reason?
Oh, no, Miss Greenhouse, we have concluded. Oh, then I have another one. Thank you, Miss Greenhouse. You have a great.
Thank you.
And
Okay.
PD Bartel, just to make sure, we don't have any pleas or anything today, do we?
No, ma'am, there are no.
Okay, great. I just want to make sure before we
Right.
cut this Greenhouse loose. Thank you, Ms. Greenhouse.
They have to
Thank
your
thank
video.
you.
This is the last call to these names. And Miss
Say William
Grace,
Davis.
if you can be quiet. Miss-
William Davis is here.
I understand, but please be quiet. Last call to these names. You have to unmute and start your video. Billy Hartage. Miss Grace, you can go ahead and prompt unmute, okay? Gwendolyn Dean, okay? William Davis, please prompt him to start his video. And Latoya. Latoya. Folks, when I ask you to start your video, this is not permission to walk around. You need to sit down. You need to sit down. If you're moving around, I'm going to remove you.
I'm sitting down.
Okay.
I'm sitting down, ma'am. I was not aware that I'd be asked to do that, and I have small children as I deal with my adults.
Sit down. Sit
I'm
down.
trying. Thank you. Thank you for your patience.
Latoya has not responded. Miss Grace, please place Latoya in the waiting room. Okay. Now, Miss Falk, are all these individuals relevant to the competency calendar?
Your Honor, I'm not entirely sure. The only individuals who reached out on the Zoom were Nashi B and Andrew Beatty. And so the other individuals, we will have to determine if they are here for the 11 a.m. calendar.
And I'm familiar, Your Honor, I know when Ms. Bennett and Mr. Beatty have reached out to me. The other folks I'm not familiar with.
All right. Billy Hartage, which case are you here for?
Autumn Beatty, she's my daughter. Andrew Beatty is my ex-husband.
Okay.
Yes, Daniel, you can carry the case.
And I'm sorry, who is the defendant in that case?
Autumn Beatty.
Autumn Beatty. Do we have a modified competency calendar?
You can add on competency calendar, Your Honor.
There was an add-on. There are three.
Okay, got it. Okay, is Miss Bennett involved in the Beatty case?
Mr. Court's mother.
Are you involved in Autumn Beatty's case?
No.
Okay, I'm going to put you in the waiting room and then we're going to bring you out when we are addressing that particular case. Gwendolyn Dean, which case are you here for?
For the 11 a.m. Autumn Beatty, I'm just a minister friend of the family.
Okay, you can stay. William Davis, which case are you here for?
I'm here on behalf of Santoine Davis.
Okay, we're going to put you in the waiting room. When we address Davis, we'll bring you into the main session.
All righty.
Okay, Miss Grace, thank you. All right, let's get to the add-on calendar on Mr. Beatty. All right, Mr. Bartel, and we need to stop the live stream